Rise. The Justice of the Appellate Division, Supreme Court, First Department. PDD, all persons having business with the Appellate Division. Draw near, give your attendance, and shall be heard. Be seated.
Good afternoon. Welcome to the Appellate Division First Department. Before I go through the calendar, it is the tradition and custom of this court that we acknowledge newly appointed justices to the Appellate Division First Department. So today it is my pleasure to introduce a newly appointed justice to this court, Justice David Friedman. He may look familiar. So it is my pleasure to welcome him back to this court. It is his first sitting, so please bear with him, okay? First case on the calendar, People v. Luis E Torres. 4, 2, and 3. So let me just say, I did not say this. Obviously, we have read your briefs. We are familiar with your arguments. So we ask, again, that you only request the time that you actually need to argue the case. Kenny versus Jacobs. Submitted. Jamie G. versus John B. Submitted. People v. Shireen Byron. Submitted. Belly versus New York City Department of Transportation. How much time would you like, sir? How much time would you like to argue? Okay.
Respondents, 5 minutes, Your Honor.
Okay. So for Mr. Belly, then 5 and 2, 5 minutes for respondents. IHG Harlem 1 versus 406 Manhattan LLC.
Good afternoon, Your Honor. 15 minutes, please.
15?
15, please. 4 minutes.
6 and 2 and 4. People v. Denny Guerrero.
Appellate request 4 and 1. Final request 4, Your Honor.
1 minute? 4. Oh, 4. 4, 1, and 4. Sit versus sit.
Appellate request 4 and 3.
4, 2, and 4. 101 Park Avenue versus the City of New York.
Appellate request 6 and 2. Respondents, 4 minutes, Your Honor.
5 and 2 and 4. Kim versus XP Securities.
Appellate request 10 minutes and 5 minutes for rebuttal. Respondent request 5.
8 and 5 and 5. Excuse me, 8 and 3 and 5. Murillo versus Amchem Products. Submitted. Brassel versus O'Neill, or Brazil versus O'Neill.
Appellants, 6 and 2.
Respondent request 4 and 2.
5 and 2. You have a cross appeal?
Sorry?
Do you have a cross appeal?
Oh, no, I'm sorry, no, you're right.
5 and 2 and 5 and 2 and 4. People v. Jose Colon. Submitted. Hall v. Shea.
Appellate request 4 minutes and 1.
4, 1, and 4. Flowcon Inc. versus Andiva LLC.
Appellate request 7 and 3. Respondent request 5.
5, 2, and 5. Cohen Goldstein versus Chalet.
Respondent request 5 minutes, Your Honor.
4, 2, and 4. People v. John Maglione. Submitted. Jess Karen versus the City of New York. 4, 2, and 4. Greca versus Choice Associates. 4, 2, and 4. Casanas versus Carly Group.
Appellate request 5 and 1. Respondent request 5 and
5, 1, and 5. Dell versus Bloomberg LP. Submitted. First case for argument, People v. Luis E Torres. You may proceed.
Good afternoon. My name is John Palmer, appearing on behalf of Luis Torres. This case involved a horrible crime. Under circumstances here, a 10 years to life sentence would adequately serve the purposes of punishment. Mr. Torres will remain in prison until he can adequately demonstrate that he is fit for release. Here, he's accepted responsibility and demonstrated a readiness to confront his struggles with addiction and trauma. We respectfully ask this court to afford him the opportunity to appear before the parole board and demonstrate rehabilitative efforts at an earlier time.
So this was a negotiated plea, was it not?
Yes, it was, Your Honor.
And in fact, he took an active role in the negotiations because he was initially against the sentence to be imposed, and he said he would take straight time.
Yes.
He said as opposed to life, he would take 20.
Yes, they did offer 20.
Okay, but again, there was the discussions, and he agreed to the sentence that was to be imposed. Is that correct?
And the fact of this negotiated plea, Your Honor, does not reduce this court's discretion to reduce Mr. Torres' sentence. In reducing Mr. Torres' sentence will not lead to his immediate release, it will not guarantee his release, nor will it undermine the gravity of this offense. Which
is very serious, as you pointed out.
Of course, it's extremely serious.
This was for an attempted rape?
It was for a completed rape, Your Honor.
A completed rape, but he had a prior attempted rape, is that correct?
Yes, he had a prior.
And in fact, he was on parole for the attempted rape that he committed this rape.
Yes. And it's certainly a circumstance that Your Honor and the court can consider in deciding whether or not to reduce Mr. Torres' sentence. And to continue reducing his sentence will not undermine the gravity of this offense. A 10 years to life sentence, he will be in prison until at least the year 2028.
How much time did he get on the attempted rape for which he was on parole?
He received 6 years.
6 years. And so in this one, he's 10 to life. Is that correct?
Yes, 14 to life, Your Honor. And the fact of that attempted rape, that prior conviction, actually increased this conviction or the charge here to a predatory sexual assault, which is why he has a life sentence potentially. But the Board of Parole will ensure that Mr. Torres' sentence, that his release is not premature, as it must consider whether or not there is a reasonable probability that he will remain in the community.
This was quite a scheme by the defendant, was it not, to lure the victim to a secluded place? The victim was the defendant's ex-girlfriend's friend, right? And he makes up a story about how he's going to give her a job and gets her to a very secluded place before he attacks her.
That's the allegation here, Your Honor. And Mr. Torres has never challenged those allegations, and he accepts full responsibility, and he has demonstrated remorse here. And thus, he has entered prison with a frame of mind that provides hope for successful rehabilitation at a shorter period of time. He acknowledged that, yes, he does need help.
Was he remorseful after the attempted rape that he was on parole for? Did he express remorse for that crime as well?
He pleaded guilty in that case as well, Your Honor, but did not have the record.
So what would be any mitigations as to why we should reduce the sentence?
As his excessive responsibility, his acknowledgement that he needs to address his issues that underlie his offending leads to the possibility of successful rehabilitation at a lower amount of time than would otherwise be necessary. And again, we are simply asking for Mr. Torres to receive an opportunity to demonstrate his rehabilitation to the parole board at an earlier time. And for that reason, having said all of this, Your Honor, this court should afford Mr. Torres that opportunity to appear before the parole board at a time that's consistent both with the purposes of punishment and Mr. Torres' willingness to overcome his past addiction and his behavior. Thank you. Thank you.
Thank you.
Good afternoon, and may it please the court, Jennifer Westwell for the people. Pursuant to a fairly and extensively negotiated plea agreement, defendant was sentenced to a prison term just 4 years above the minimum for luring his victim to a secluded area, forcibly throwing her to the ground and manhandling her, threatening to hurt her, and ultimately raping her. At the time that defendant raped this victim, he was already under parole supervision, from which he had absconded for a previous attempted first-degree rape.
So he was sentenced to 14 to life. He wanted 10 to life. Is that correct?
That's correct, Your Honor.
Max was 25?
25 to life. And he had, in fact, asked the sentencing judge to consider as low as 10 years.
The DA had wanted 15 to life, right?
Yes.
This was a plea taken without the people.
I'm sorry?
This was a plea taken without the people's consent, right?
Yes. And as I've mentioned, the sentencing judge was well aware of all the factors that defendant cites to on appeal. He had the judge had the pre-pleading memorandum, which actually recommended a sentence of 15 years. The sentencing judge balanced those factors against the severity crime and came up with the offered sentence. The negotiated sentence was both fair and appropriate and should not be disturbed on appeal. Thank you, and I request that you affirm.
Just like to briefly note two things, Your Honor. Your Honors, first, yes, the court was aware of these circumstances here in this case, but we do not need to say anything new or bring any exceptional circumstances here for this court to reduce Mr. Torres' sentence. And further, yes, the pre-preliminary memorandum did suggest a 15-year terminate sentence, but just because that time frame is more than the 10 years he'd be required to serve if this court reduced his sentence does not mean that that is a lighter, that 10 years to life is a lighter sentence.
I thought, did your adversary also say that the pre-sentence report also recommended 15 to life?
15 years to terminate sentence, which is a
determinate.
much lower sentence than 10 years to life, even though the required time is lower. As under 15 years to life, of course, you get out in 15 years, the maximum expiration date.
Was the prior attempted rape his only other prior?
Yeah, he had other offenses, I believe all misdemeanors, and a youthful offender adjudication. And under 10 years to life, as I was going to say, Mr. Torres currently has no maximum expiration date. He can and possibly will be in prison for the rest of his life. And all that we ask this court is for an opportunity for him to demonstrate rehabilitation to the Board of Parole at an earlier time. Thank you.
Thank you. Belly versus New York City Department of Transportation. Justice Friedman is recused on this matter.
Good afternoon, Your Honors. My name is Mark Belly. I'm a civil servant employee. I'm a civil service plumber for the city of New York. I brought this case should have never been dismissed.
So, Mr. Belly, you no longer work for the Department of Transportation, is that correct?
Correct. I work.
And that's no longer an issue in terms of any employment with the Department of Transportation, is that correct?
I put in my papers that I should be brought back to work for the Department of Transportation.
So is it you want to work for the Department of Transportation, or do you want to work for HRA?
I was wrongfully terminated from the Department of Transportation. I put that in there to show how the rules, the PSB rules, are inconsistent. I use that as an example.
I see.
All right, but more importantly, the forefront of this was I filed for a declaratory judgment about the PSB's rules, one of which is a conditional leave of absence. With DOT, there's another PSB, which the PSBs are an executive order from the mayor of the city of New York, which I'm sure is the head of the city of New York, not my supervisors and people who misinterpret as the mayor's executive orders. But there is a PSB that I included in my exhibits that show that every city employee, with some exceptions, there's an accepted group, policemen, emergency service people, firemen, 911 callers, every city employee is entitled to a 5-minute grace period. And there's an inconsistency with these rules throughout several city agencies. Joe Mastergiulio, who I named, who is the licensed master plumber for the Department of Transportation, stated when the DOT let go of me and I filed for unemployment, we had an unemployment hearing, he stated that if it wasn't for my latenesses, which were all less, which I think there were 3 or 4 of them, they were late, they were all less than 5 minutes. He stated during the unemployment hearing that I had to challenge to get my unemployment. He stated that if it wasn't for my latenesses, he doesn't think I ever would have been terminated from DOT. And the reason that I named them was to show that inconsistency. Some agencies allow it. At that time, DOT did not have a 5-minute grace period in the morning because they had it at the end of the day because people wanted to go home early. So somebody made a decision, okay, let's let people leave 5 minutes early. That's not what the executive order says. At this time, where they have a different director of the trades at DOT, at this time, they now have it in the morning. If I was working for DOT right now, I would have never gotten fired. The only reason that I was late is on the Belt Parkway, if anybody's familiar with it, there's a drawbridge. And that drawbridge on these occasions is what caused me to be late. When the drawbridge comes up, sometimes it takes 20 minutes, and I was driving to work. For a declaratory judgment, my understanding is that when I filed this case for a declaratory judgment for the PSBs and some other things, it's an action case. It's an ongoing case. It's my understanding that the court should have said, yes, these rules apply to you, or no, these rules do not apply to you. I argued them in front of one judge, and then I got a dismissal with another judge who made the decision. I included my oral arguments in court as part of, in the documents, the record. And I don't think my case ever should have been dismissed. And it just shows that the PSBs and the time and leave rules, the inconsistencies, we are not in a classification that we're excluded from this. We don't have the floating holiday, and certain other classifications of works do have it, not the 220 labor law, plumbers, carpenters, and everything else. I don't think my case ever should have been dismissed by the lower court, respectfully.
Okay, so Mr. Bailey, we're going to hear from your adversary, New York City Department of Transportation et al., and then you'll have an opportunity for further statements.
I can leave my things here for a minute?
Sure, if they're not in your way, sure.
Thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of respondents. With the court's permission, I'll focus on the claims against HRA, Mr. Belli's current
I just
employer.
do want to go back to
Yes, Your
DOT
Honor.
for a second.
Yes, Your
So
Honor.
with DOT, Mr. Belli stated that the PSB did or did not apply.
So he believes that the PSB does apply to him. We dispute that contention because the PSBs turn on whether he's a member of the career and salary plan, and he has not alleged that he's part of that. And in fact, he's admitted that he's a prevailing wage employee and outside of the citywide collective bargaining agreement, which means by definition he's not in the career and salary plan. But there's a separate and independent reason why the unlawful termination claim was properly dismissed as the DOT, because there were two reasons interposed for the discontinuance of his probationary service. And the second one was the sending of a note with unwanted sexual undertones to a colleague. But regarding the declaratory judgment claim against his current employer, there are several...
And that's HRA.
That's correct. That's HRA. There are several fundamental problems with the claim that warranted dismissal. First, we don't think the PSBs apply to him. Second...
And so you don't believe the PSB applies to him for HRA for the same reasons they did not apply to him for DOT?
That's correct.
Okay, the classification.
That's correct. And
Okay.
even if the claim isn't moot, because to the extent he's seeking a declaration that HRA allow him to take a conditional leave of absence, he was permitted to take a conditional leave of absence. But a declaratory judgment is incumbent on there being some sort of live, present, justiciable controversy that needs to be quieted. But here there is no non-conclusive...
Well, he's stating that the PSB does apply to other agencies and individuals such as he who are similarly situated at those other agencies?
He believes that they apply to him for sure. We dispute that contention. But so if I'm an employee and I believe that my employer is not abiding by certain rules, I don't get to come into court and seek a declaratory judgment unless there's been some effect on my legal rights. And here there's just a lack of aggrievement because there's no non-conclusory allegation that Mr. Belli has been or will be aggrieved by any alleged failure to apply the PSBs to him at HRA.
Sir, isn't Mr. Belli currently reinstated with HRA today?
He is currently working for HRA today, yes, Your Honor.
And his concerns about earlier allegations by a former supervisor, I don't know if Mr. Patel is still a supervisor today.
I believe Patel is at HRA, Your Honor, yes.
Right. So when he left HRA, there was like certain complaints against him was held in abeyance.
Yes, Your Honor.
Back. And as I understand on the record, that's been fully resolved.
Yes, correct, Your Honor.
So basically, he's back where he is. All is right as rain.
That's correct. The 4 disciplinary charges had nothing to do with any time or leave issues. The charges were sustained. Mr. Belli was given an opportunity to challenge those findings. A recommended 45-day suspension was proposed, but ultimately the parties negotiated a 5-day suspension. So because there's no need to quiet or settle any disputed rights as to HRA, and because his discrimination and retaliation claims, if not abandoned by not mentioning them in his briefing, they otherwise fail on the merits as explained in our briefing. Unless this panel has any further questions, this court should affirm the dismissal of the complaint for failure to state a claim, given that each claim has either a fundamental procedural defect, a fundamental substantive defect, or both.
Thank you.
Thank you, Your Honors.
So, Mr. Belli, you have 2 minutes to respond or state anything you wish to state concerning your claims.
I didn't write down everything that he said that I would like to respond to, but I can respond to everything. He made a statement that I had a 5-day suspension. They did at oath. I hired an attorney, and originally I agreed to a 1-day suspension, which turned into a 5-day suspension retroactively because HRA did not bring me back within 7 months. So I really didn't lose any time. To be quite honest with you, it wasn't worth it for me to pay another $6,000 to go to trial when I could just take a 1-day suspension. I signed off for it, and then it turned into a 5-day retroactive suspension because I didn't understand what I was signing. But I disagree. This claim does cause, this is a judiciable controversy. I didn't pronounce that properly, because it is a continuing dispute as to whether these rules apply to us. There are many of these rules. I've had supervisors tell me in the past, You're not allowed to take time off from work 3 hours, up to 3 hours, to donate blood. That's a PSB, okay? To illustrate, for over 7 months, I was writing letters to HRA. I included some of those documents. I was calling HRA, hey, when can I come back? I have a conditional leave of absence. The PSB for the conditional leave of absences allows that if things don't work out at DOT for whatever reason, I can come back to my original job. It states in the PSB, upon written, they have to reinstate me and end my leave, my approved leave. That never happened for 7 months. It wasn't until I hired an attorney to get me my job back, and the last day before the 1 year was over, I'm sorry, I'm running out of time. I'm seeking mixed relief. I'm looking for, can I keep on talking?
Just finish that. What are you looking for?
The declaratory judgment as to whether the rules apply, seeking monetary compensation for being brought back late from my conditional leave of absence, which shows retaliation because I was complaining about us not having a licensed master plumber as required by law. It's a terrible thing because it's led us to do illegal plumbing. And also the exposure prevention plan. It's a terrible thing. We are doing stoppages and we don't have an exposure prevention plan where all of the plumbers are exposing themselves to potential bloodborne pathogens that you can contact diseases when we're doing stoppages. And we need to have a plan as required by OSHA.
Thank you, sir. We're going to, thank you for your arguments. Thank you both.
Thank you. Have a good day.
Take care. IHG Harlem 1 versus 406 Manhattan LLC.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. Gabriel Korinman for the appellants. In this case, the sellers were not in breach. The things that the purchaser claims constitute breaches under the contract were not breaches under the
let me
contract.
just ask you a question directly about Section 10.14 of the contract, which required the seller to assign the existing mortgage. And the court, granted summary judgment on that issue. That's clearly the language of the contract. How is that not a breach if it's not done?
You're referring, I'm sorry, to which section, Your Honor?
10.14.
10.14. Okay.
We're talking about
10.14, maybe?
the assignment of the mortgage.
I'm sorry, can you?
The assignment of the mortgage.
The assignment of the mortgage, yes, Your Honor. So the complaint alleged that the seller's refusal to request an assignment of the existing mortgage to a purchaser is a breach of contract. Now, this is not a breach of contract because, number one, the contract does not require the seller to provide the assignment, and the seller did not refuse to request the assignment. But most importantly, this was not a material condition in the contract. It doesn't even contain a condition, and the reason is it doesn't identify the mortgage at issue, it doesn't identify the time to effectuate the assignment, but most importantly, the condition, if is
the assignment, but
impractical or
counsel, according
Yes.
to my understanding of the record, the assignment was a big deal to the buyer because that was going to provide some tax savings, enormous tax savings.
Exactly. I was going.
So it was
yes,
really
yes, Your
a
Honor.
big part of the negotiations, correct?
Well, that's precisely another issue with that clause, which is that provision is otherwise illegal. And the reason it's illegal because, as recognized by the same purchaser, the purpose of that assignment was to avoid the payment of the recording taxes. That was admitted by
That's not illegal. That's just it's not, you're not avoiding a recording. If you can manage some way to avoid paying a tax, I mean, people, a lot of, in terms of avoiding taxes, it's not illegal. People just find loopholes, right? I mean, this is a loophole.
Well, but this is a loophole that that it's illegal, and the reason I say it's illegal is
Okay.
because, and we mentioned that in the brief, the New York State Department of Taxation and Finance, in connection with the amendments of Section 275, addressed precisely this situation where some people, use old mortgage liens to obtain new loans and therefore escape the mortgage recording tax. And that's precisely the situation that it's not permissible under New York law. And this court has said that when illegal obligations
Did you make that argument before Supreme Court below?
I'm sorry?
Did you make that argument before the Supreme Court below, that this transaction of the assignment was illegal?
We made this argument. We made this argument on our brief. Yes, Your Honor.
Before the trial court?
Before the
Not
lower
with us,
court.
but before the court below.
The argument was made in connection with a motion to re-argue. It was made before the court below to that extent, Your Honor.
You made it in the motion to re-argue. You didn't make it on your original motion then. Okay, I just want to make sure that the argument you're raising was the court below had an opportunity to look at it. Okay.
But definitely on the court below, the enforceability of that provision was put in question.
All right.
By the way, that's not a material condition for a contract to, for a condition to be constitute breach of contract. The breach of that condition must be substantial to the extent that it defeats the object of the parties entering into the contract. And the object of the parties entering into the contract was not to afford an opportunity to respond and to save the mortgage tax that it was required to pay in connection with the mortgage loan.
Obviously, a bargain for provision in the contract, and as I think it was Judge Ung said, there was the point of trying to save all this money on taxes. Why wouldn't that? There was the point of trying to save all of this money on the mortgage tax. Why wouldn't that be a material term?
Because as I mentioned, this is not permissible.
Let me put the question a different way. What penalty is to be imposed upon you for failing to provide the assignments?
This issue was precisely addressed, and it's not and when the Section 275 was amended, and this is precisely the kind of situation that it's not permissible to use, an old mortgage for a completely new loan, different borrower, different obligation. That's not what the law envisions. You have to pay the mortgage tax. But regardless,
ultimately,
you said that you agreed to an illegal provision in the contract. Is that what you're saying?
I'm sorry?
Are you saying that you agreed to provide something which you were legally prohibited from providing?
I have a hard time. I'm sorry.
You were supposed to provide these assignments, and now you're saying utilizing these assignments is not legal. So did you agree to provide something which wasn't legal?
Well, this is something.
Can you answer the question? Did you agree to something that was not legal?
But that was not the agreement. We are rejecting the notion that that was exactly what was agreed on. But one thing that it's important to mention regarding this.
You can mention it on rebuttal. Thank you.
Okay. Thank you.
And then while you're waiting for rebuttal, you can fix your mask so that the mask covers your nose.
Yeah, I'm sorry.
Mouth. Yeah, I know it's slipping.
Apologize.
Okay. Mask, they're supposed to cover your nose as well as your mouth. Okay, it's not like a little slip thing that goes in your mouth. Okay.
Your Honor, may it please the court, my name is Jacob Feinstein. I represent the respondents, IHG.
If you could address that issue, because I'm not,
Sure.
I really do not understand.
Yeah, the answer to your question is that Section 1.03C of the contract does not, it provides two different ways at the closing to satisfy the previous mortgage. It's not required, clearly not required in the contract to pay off the mortgage in full and to obtain a satisfaction. One of the ways to deal with the issue of a mortgage, a prior mortgage on the property, it says in the contract is that
you take over the existing mortgage. Some people do that. I mean, that's not illegal. I mean, you got a huge.
That's not legal at all. It's not illegal at all. But
and the bank may like that because the bank may get to still charge a higher interest rate instead of a lower interest rate. So that's the way it goes. You get assigned the old mortgage that's pretty big still, and you take the responsibility to pay for it. And at the same time, you avoid paying a new recording tax. It's already taken care of. There's nothing wrong with that.
The contract provides that the seller just has to bring a payoff letter, and that's it. And then we come ahead.
This sort of assignment with the mortgage is a rather standard operation in real estate practice.
This is an appellate court, but I can tell you that I've been doing closings for the past close to 40 years, and this is the first time I've ever heard this was illegal. And in addition to that, if you read the memo decision by the New York State Department of Taxation, it says specifically that this is a permitted way of doing business.
Yeah, because the banks are like that. The banks kind of like if they can
It's
charge
exemplified.
higher interest rate.
I would say something, if any attorney does not advise his client to go ahead and to do an assignment of a mortgage, I think he's committing malpractice and nothing illegal, but that's the way
Putting
he's
aside the assignment, there was also another version or another condition in the contract that wasn't satisfied, and that was the regulatory part.
That was the regulatory agreements. Regulatory agreements were simple. The title called regulatory agreements. The regulatory agreement doesn't mean, because they use the word regulatory, does nothing to do with a governmental zoning type. It's a regular contractual obligation between the HPD and a buyer of a property who many times the city went over, took buildings that were completely shells. They went over, provided financing. We have one of these buildings that they're involved here. The purchaser paid $1 for the building. And the condition was that they were going to go ahead, get financing, build the building up, and provide for 30 years for low-income housing. If somebody violates that agreement, it goes from 30 years to 40 years. That's a big burden on the buyer. My clients, when they went to go and buy the property, they found that they needed to know whether or not the value is there with the property. They're entitled to that. And in addition to that, if the property was violation of the agreements, then at that point they would not be able to do business with various governmental agencies.
Counsel,
Turn your attention to something else. Let's assume that the sellers were not in a position to demand your performance because they hadn't done the assignment and maybe they were in violation of the regulatory. But what's the remedy that you're entitled to for the seller's breach?
Okay, in this case, because of the other nature of the deal that took place, this case is entitled, in the contract, they're entitled to specific performance. And in addition to that, there's a little part of the story here which was not spoken out in the court. The reason why he didn't perform on the contract was because of him trying to extort an additional $1 million from my clients. Now, when they went over and they had the specific performance, what happened in this case was that my clients were trying to get specific performance, but in the year 2019, the statute...
The price no longer made sense. But
made no sense at all.
Why isn't the remedy for you just to get your deposit back?
That's not the remedy. I'm entitled under the law, there are many cases that say that under the law, if somebody goes ahead and deliberately breaches on a real estate contract, you're entitled to the benefit of the bargain. And that's the law. I can give you a number of cases which have that holding. We're asking for the benefit of the bargain because we're entitled to that. And in addition, when we have specific performance, it's no longer there. When you cannot get specific performance as a court of equity has the right to go ahead and to order a trial for damages. There are many cases on there dealing with this issue, and the courts have dealt with this. This department has dealt with it in the Mora case as being one of the cases, but when you have a specific performance case, when the equity is not, where you can't go ahead and do that, that remedy is not there, you're entitled to the benefit of the bargain. In addition to that, this case is also a situation where the seller didn't just accidentally not sell the property, but the seller went out, demanded $1 million more. And if you take a look at deposition testimony, which is part of the record and it's in the brief, questions were being asked of the seller, and the seller just, it's a comedy routine that was going on. He refused to answer anything. And the seller is a sophisticated person. He owns numerous buildings. He has 300 apartments that he's managing. And when questions were asked him about the regulatory agreements, his answer was, I don't have to tell you. That's what we're doing. We were trying to buy. He was sitting there hoping that the deal would crater, we'd walk away, and then the market tanked on it.
Thank you, Counselor. Justice Pitt, you had a question? Okay, thank you.
So again, we're entitled to get damages and have a trial like Judge Cutler ruled.
Thank you. Yes, you have 2 minutes on rebuttal.
The first thing I wanted to say regarding the assignment clause is the purchaser was served with a time of the essence letter. They didn't object. They didn't appear at the closing. They didn't raise the assignment issue at that time.
I don't want to cut you. Let me ask you this question, and this is to the last point that he was talking about, the damages portion.
Yes.
Why do you think he's not entitled to a trial on damages?
Well, the contract specifically provided for the consequence of the failure to convey for any reason. That's what the contract says in section 5.05b. If the seller shall refuse or fail to convey the property for any reason, then the purchaser, et cetera, the purchaser shall elect as its sole remedy, an exclusive remedy, to either terminate the agreement and recover the deposit, okay, or enforce specific performance. But they abandoned the specific performance. The court, with all due respect, cannot rewrite the terms of the contract. That's what the parties bargained for. And no matter what allegations they can make about, market fluctuations and things of that kind, that's what the parties agree. And there is case law, we have even from the Court of Appeals, matter of Part 60, put back litigation from 2020. A public policy you can't rewrite based on considerations such as public policy or other considerations. The contract specifically provided for the consequence of any failure to convey the property. So even assuming if there was a breach by the seller, that's what the parties agreed on.
Thank you. People v. Denny Guerrero.
Good afternoon. Benjamin Rutkin-Becker on behalf of Denny Guerrero. I'd primarily like to discuss Mr. Guerrero's sentence today, but first, just a few words about the plea withdrawal issue. The home is at the core of Fourth Amendment protections, and here the suspected drug sales were insufficiently tied to Mr. Guerrero's home to justify a search. So we would ask your honors to suppress the evidence found in his home and vacate Mr. Guerrero's guilty plea.
You said the plea withdrawal. Was there a motion to withdraw his plea?
There was not, Your Honor. But because there was a motion to controvert the warrant, so this issue is preserved for appeal, and because the evidence found in Mr. Guerrero's home was a critical component.
So there was a motion to controvert the search warrant. That was ruled upon, and then there was a MAC hearing. There was a hearing as to the suppression. Is that correct?
There was not a separate suppression hearing. This is a warrant issue, Your Honor. The issue here is that the warrant application did not set forth sufficient basis to believe that evidence would be.
So did the court review the warrant, and did the court make a determination as to the allegations in the warrant as to whether they established probable cause or not?
Yes, Your Honor. The motion to controvert was denied after consideration by the court. That led to Mr. Guerrero's guilty plea. So this issue.
Okay, I'm assuming there was an ex parte review of the search warrant, and the people supplied the unredacted copy of the search warrant and the search warrant affidavit for the court's consideration?
Yes, Your Honor.
And so one of your issues, your issue on appeal, is that the defendant should not have been required to waive his right to appeal as to the suppression issues?
That's correct, Your Honor. We believe that that is an issue that ought to be revisited, that appellate waivers should not cover suppression issues, especially in cases so affecting public policy and police conduct.
And what about
here.
Thomas et al. And the decisions by the Court of Appeals where they say that it is permissible?
That's right, Your Honor. We believe it's time to revisit those decisions. However, the waiver here was invalid.
We can't revisit it. The Court of Appeals would have to revisit it.
Understood, Your Honor. The purported waiver here was independently invalid under Thomas Bissono and the Court of Appeals' recent precedent. However, I would also like to turn to Mr. Guerrero's sentence. 8 years incarceration is simply unnecessary for someone who has zero history of violence, a history of productive employment, family support.
Oh, did he not? I thought he also had a federal, I may be mixing up the cases. Is he the gentleman who had the federal conviction for drug conspiracy to sell drugs?
He did, Your Honor. He had a 1990 conviction. He did serve time in federal prison for that conviction, but that conviction was too old to constitute even a predicate felony.
Is that his only prior?
So, Your Honor, the PSR references two federal drug convictions, one from while he was in prison. Mr. Guerrero contests that second.
Right, so the allegation was that while he was incarcerated on the drug conspiracy charges, he also committed additional conspiracies to distribute drugs?
That was the allegation, Your Honor. Mr. Guerrero does contest that happened. We don't know where that information came from, but it was in the PSR. And even accepting the truth of that allegation, Your Honor, that does not justify an 8-year prison sentence here.
And are we talking about, in this particular case with the search warrant, are we talking about drugs as well?
Yes, Your Honor, there were drugs found in Mr. Guerrero's home he should be entitled to suppression of. And if there are no further questions, I'll reserve the remainder of my time on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. Defendant's conviction should be affirmed. First, defendant has waived his right to appeal both of the issues raised in his brief. The court engaged in a detailed colloquy with defendant to ensure that he understood the rights he was giving up, and defendant signed a written waiver. The record demonstrates that the waiver was made knowingly, intelligently, and voluntarily. In any event, contrary to defense counsel's arguments, there was a nexus between defense's apartment and the drugs which were recovered there pursuant to the search warrant. The detective's affidavit established that the defendant had generally known to be engaged in drug trafficking based on his phone communications with a co-defendant named Debo, another known member of the drug enterprise. On February 7th, police intercepted calls indicating that the defendant and Debo had arranged to meet at a storage unit rented under the defendant's name so that the defendant could supply him with marijuana. Later that day, defendant was seen leaving the storage unit and driving to his apartment, then wheeling a cart into the parking garage of his apartment. And that same day, Debo also told defendant that the package he had opened was quote-unquote heavy. Based on all of these observations and the detective's experience, he believed that the defendant had also brought a heavy package back from the storage unit that day and brought it into his apartment.
And the search warrant was executed on the storage unit, is that correct?
It was executed on the defendant's apartment, the storage unit, and the defendant's car. Those are just the targets pertaining to this particular defendant. There were other targets as well, but those three in particular. And as the affidavit makes clear, the detective believed, based on his observations, that defendant was using both the storage unit and his apartment to store drugs, and that he was using his car to transport them back and forth between the two.
So the defendant was sentenced to what, 8 plus 5?
He was, yes, correct, Your Honor. He was sentenced to 8 years in prison and 5 years of post-release supervision. He did.
What was the max?
The max on the top count in the indictment was 20 years. The people agreed to allow defendant to plead to a lesser included offense. I believe the max on that is 7. I may have that incorrect, but that was an A2 felony. And so we would submit that that is perfectly fair and reasonable sentence under the circumstances.
So how much above the minimum did he receive?
Well, he pleaded guilty to 8 years on the A2 felony, but if he had pleaded guilty to the top count in the indictment, the minimum on that would have been 8 years. And as we submitted in our brief, we believe that that
What's
is.
your response quickly about how, assuming that there was a valid waiver of the appeal, the argument, at least my understanding, is that that waiver is too broad. It shouldn't encompass suppression rulings.
Again, Your Honor, as Justice Weber already noted, the Court of Appeals has already ruled on that, and our position is simply that this court's not in a position to revisit that issue, and it would be up to the Court of Appeals to overturn that decision. Unless there are any further questions, we ask that you affirm.
Thank you, Your Honors. Turning back to Mr. Guerrero's sentence, the range here on the count that Your Honors are considering, the count of conviction is 3 to 10 years, and he's serving 8 years of incarceration.
What did the other 3 co-defendants receive? One received 6 years. What about the other 3?
That's right, Your Honor. So 2 individuals who were charged with the same crimes as Mr. Guerrero. There's Gene Rodriguez, who was supposedly...
I just asked for the years. What are the years that they get?
4 years, and then there was 6 years on another individual who was,
right.
like Mr.
And how
Guerrero
about the other
referenced.
3 that got longer sentences? What were their sentences?
Yes, so there were 3 individuals who did get longer sentences. 2 of them got 10 years, 1 got 12 years. And it's important to note, Your Honor, that those 3 individuals were the leaders of the operation. They were found guilty after trial. Unlike Mr. Guerrero, they were second violent felony offenders. Mr. Guerrero was a first offender. And 2 of those 3 were also found to be guilty of additional firearms charges. So if anything, Your Honor, the disparate sentences of Mr. Guerrero's co-defendants...
He was the first offender, but he had 2 prior federal felonies, didn't he?
He did, Your Honor. Again, we do contest that he had 2. He clearly had at least 1. And even accepting that information, that he had 2 prior federal felonies, they were from 1990. And the record shows that in the interim between those convictions, which were too old to be considered.
Did he receive, was it from 91 and 92, wasn't it? And didn't he receive 10 years on one of those charges?
He did, Your Honor. He did receive 10 years. However, the record demonstrates that he has the ability to live as a productive member of society.
And he wasn't on federal parole for those cases?
Your Honor, we just have limited information from the PSR here. It is not my belief that he was under federal parole at the time of the instant offenses. I'm not sure how many years, if any, of federal parole he served.
Thank you.
Thank you, Your Honors.
Sit versus sit.
May it please the court, my name is Robert Kaplan. I'm the attorney for the appellant, Jack Sitt. The appellant believes that this appeal turns on a single legal issue and an issue that is not subject to serious doubt.
And what is that issue?
That issue is, what does a party moving for summary judgment have to come forward with? In this case, the motion court awarded respondents summary judgment.
Yeah, but I understand you want to phrase the issue that way, but isn't there another way of looking at this issue? You're facing dismissal by the court for failure to prosecute, and the judge says, I'm going to give you one more chance to go forward with this, which you've allowed to languish for a long time. What properties are you raising an issue to?
Because the judge
But you
didn't,
don't raise, but
Counselor.
you didn't raise an issue as to what you're now contending about 6 Times Square. You didn't then say that that's one of the properties that you've got a claim about.
no, Your Honor, that's not correct. That in opposition to the respondent's summary judgment motion, the appellant said that I want these claims to go forward. If the defendant doesn't come forward with any evidence whatsoever, there's no dispute. Defendant said that he came forward with any evidence. There is none.
At some point, the appellant himself said that, right? But
No,
it wasn't,
no, sir, no, no.
It wasn't, or the attorney
No,
related.
no,
that
the
that's
attorney
what-
didn't say that either. You know, you should look, we'll look at exactly what he said. What he said was, okay, first, the appellant said in his affidavit, the memorandum of law that he submitted, he made clear that he was not relinquishing his right to pursue these claims. Respondents, in their brief, admit that appellant continued to maintain that these claims remain contested. Appellant's counsel didn't waive anything. He expressly stated that appellant believed these claims should go forward. He expressly referenced what appellant had said in his papers concerning those claims. That attorney did not have the unilateral authority to waive the claims, and he made clear that the plaintiff, that the appellant was not waiving those claims. If the court wanted to dismiss these claims because of failure to prosecute, whatever, the court could have said that, but the court didn't. The court granted the defendant's summary judgment dismissing these claims. And we all know what burden someone has to carry on a motion for summary judgment. And they didn't even attempt it. They don't even claim that. You look at their papers, they submitted 6 sets of papers over nearly a 4-year period. Did they ever mention these claims here? They did not. Now, I'll remind you.
So, counsel, let me just stop you for 1 second. We're talking about the claims related to 6 Times Square member LLC, correct?
The damage claims.
Right. Well, I just want to make sure we got the right.
Yes.
We're looking at the claims for that entity.
Yes.
And I'm looking at page 1616 of the record, where the court says the entire universe now is going to be the enumerated claims solely with respect to 1370, 145, 240, and 1369. So all those claims solely limited to those property plus disbursements, whatever. Mr. Lazarus, that is correct, with one more caveat, and that's the thing talking about 145 Spring Street. That's it. So, am I reading that wrong?
Your Honor, as I pointed out, he didn't have the authority to waive the claim. A different part of the
You know what?
record.
That's between him and his client, then, right?
No, not at all. He said what he reiterated what the appellant's position was. It's expressly in the papers.
Got it.
Thank you.
Good afternoon. May it please the court. My name is Stacey Ashby of Meister Seelig & Fine for the respondents. Your Honor seized upon exactly what the trial court saw.
I mean, that was a big part of the problem with trial counsel below. Before the court, your attorney, your colleague was saying, we got a problem. We got to know exactly what we're facing, Judge, because we don't know where we're at. And that's what Justice Cohen basically said, okay, what do we got here? And why would he need to dismiss something if the other side, if the plaintiff's going to say, okay, you know what, these are it. So there's nothing else for him to do. I mean, I can only take at face value what counsel is representing me, saying, this is the universe of claims, period. I'm not going to say, did you have authority to do that? I mean, that's not the role of the court at that point.
That's correct, Your Honor. And to also quote the trial counsel for the appellant, when specifically asked at the October 2020 argument about what claims he was proceeding on, Mr. Lazarus said, if it's not listed, we are not proceeding on those claims. And then Judge Cohen hammered home the 2 Herald
Well, that's
specific
because
claims.
the other, your colleague was saying, well, that's not good enough.
Well, Mr. Lazarus was representing Mr. Sitt in the trial court, and so I dispute that he didn't have authority to waive those claims or not proceed on those claims. Appellant was put on notice by the trial court to come forward with evidence after having years of discovery and apparently also having an expert accountant look at these books and records since 2015, and he never substantiated, he never put any flesh on the bones of those two Herald claims. The respondents don't deny that when they first filed their motion to dismiss in 2016, prior to this property being lost in foreclosure in 2018, that we didn't seek to dismiss. But what we then did in 2019, after appellant had failed to prosecute his case for 2 years, was to supplement the record with additional arguments pursuant to CPLR 3126, which allows the court to dismiss part or all of an action for the failure to disclose. If there's any other questions, I will yield the rest of my time. Thank you.
Thank you.
Yes, I have 3 points I want to touch on. The Respondents' Counsel refers to the judge demanding that they come forward with evidence. Well, the judge doesn't have the power to do that. There are 2 opportunities to test the cause of action prior to trial. Motion to dismiss, motion for summary judgment. If the defendant can't show that the cause of action should be dismissed as a matter of law, then that's the end of the story. The claim goes forward. Burdens on the respondent.
Wasn't there really an agreement? These are the properties that we're going forward on.
The attorney in the trial court specifically referenced the appellant's desire to go forward with those claims. And in the paper said he wanted to go forward with those claims, and he said in open court that the appellant wanted to go forward on those claims. So I think, to my mind, it's clear that the appellant wanted to go forward with those claims, and the defendant came forward with nothing concerning those claims. Nothing. If it was waived, if the judge decided his claims were being waived, he could have said so in his decision. He didn't. He said, I'm granting summary judgment. He's not saying I'm granting it because of waiver. He said, I'm dismissing these because they've been waived. He said he's granting summary judgment. And he has to be evaluated by the standards applicable to a motion for summary judgment. Finally, the defendant refers to their motion pursuant to 3126. Well, first of all, they only asserted that in the alternative, and because the judge gave them leave to convert their motion to a summary judgment motion, that motion never really went forward. And anyhow, the court did not grant that motion. It was you just look at the order, summary judgment. The court specifically declined to grant any discovery sanctions. He did say, you're right on the edge, but the order actually said summary judgment. And that order has to be evaluated by the standards applicable to a summary judgment motion, and a cause of action cannot be dismissed if the moving party fails to satisfy its burden.
Thank you.
Thank you.
Matter of 101 Park Avenue versus the City of New York. You may proceed.
May it please the court, my name is Richard Lobel, and I represent 101 Park Avenue Associates 2 LLC in this matter. Your Honors, this case is about the ability of a property owner to be able to rely on the plain language of a zoning statute and to be free from arbitrary enforcement of that statute by the city. To that end, we argue 2 main points. First, the lower court erroneously deferred to the Oath Appeals Unit here, as the question presented was one of pure legal interpretation requiring no special expertise to resolve and should be reviewed
It's all about the term within the window, right? Whether or
Correct.
not the sign, the illuminated sign that's 49 stories above, right? And we have it in the record, the photo, what it looks like, calico, Is it, the way they looked at it is within 8 inches, they're gonna say it's within a window, right? And
Correct,
you're
Your Honor.
arguing that there's no clear definition of what's within a window so that it could be arbitrary, right?
Absolutely, Your Honor. This is,
But have you found any cases that have said that within a window is beyond the 8 inches? Has there been any administrative rulings that have said like, okay, 16 inches is still considered within a window?
well, the problem, Your Honor, is that.
Yes or no? I mean, that's a yes or no answer.
No, the answer is that there's only one case that has said that put down any standard, and that was the Microsoft case.
Yeah, but that was 8 feet.
Correct.
That was 8 feet. That's,
Correct, Your Honor.
That you can't, we can sit here and say, that's not
Of course.
in the window, right?
Yes, Your Honor, but in that case, the BSA, the Board of Standards and Appeals, which is the ranking zoning agency
Yeah.
in this city, told the Department of Buildings that it was disturbed by the subjectivity and uncertainty in DOB's performance.
Yeah, because DOB said 8 feet was within a window, and that prompted BSA to say, you know what, that's kind of like a little strange that you would say 8 feet is within a window. I mean, so that's where that's coming from. You have like a different set of facts, a different set of measurements here.
There's no difference of the facts, Your Honor.
Yeah, 8 inches versus 8 feet, that's not a difference?
Absolutely, it's not a difference of the facts in terms of what's in dispute here. We understand that they came with a tape measure. That is how they are enforcing the rule. The problem, Your Honor, is that the rule doesn't contain a measurement. It merely says illuminated and located in a window. In fact, what the rule does say is it contains the statement is visible from outside the building. But then it says a sign, including a writing, within a building only when illuminated and located in a window. Your
So
Honor.
you're saying that the rule itself is vague?
The rule is absolutely vague, Your Honor. It offers no notice and no definitive statement whatsoever. There are Department of Buildings enforcement
So it
agents.
should say between 8 inches and 8 feet?
Absolutely not, Your Honor. We say that zoning is in derogation of the common law, that ambiguity should be resolved, and this is the Exxon Corp case decided by this court. Ambiguities must be resolved in favor of the property owner. There's no notice here. There's no standard here. In a window has to be
So
determined.
tomorrow, if we come down and agree with you, tomorrow they change it to say, okay, 8 inches is in a window. What are you going to say at that point?
Assuming that they go through proper administrative rulemaking
Yeah.
procedures and they amend the zoning, of course, we cited the Grusin case where the Department of City
So let
Planning
me
went
ask you
back.
this question. This ruling doesn't mean you can't have that sign up. This ruling basically means you got to get a permit for the sign, right?
That's not the case, Your Honor.
That's not the case. You got to take the sign down?
No, Your Honor, I'm sorry, I don't understand that. What it says is
Right.
that we don't even qualify as a sign. You're
I
only a
understand,
sign.
I understand that. You don't qualify as sign, but you can still put up something, but you got to get a permit for it, correct?
I don't understand the question, Your Honor.
Okay, let me rephrase that. Is there any way for you to keep that sign up? It's a sign, right? That they're
Correct?
going to issue.
No, it is
a vi-
not a sign. Under the zoning, it is not a sign.
But they said it was a sign.
Correct.
Okay, so they're saying it's a sign. So what does that mean? That when they say it's a sign,
I understand, Your Honor. You would need to adhere to other requirements in the rule.
Right.
And that's my point. The other requirements in the rule talk about being 25 feet over the curb limit.
Right.
Talk about the square footage of the surface area being 200 feet.
You know,
These
you
are all
say- You
things.
say that there's ambiguity, but yet when you look at the picture of the sign, it certainly appears like it's in the window. It cannot come to you as any surprise that the city turned around and said, this is in the window.
It is a surprise, Your Honor, for the reason that in Microsoft, the display at question in Microsoft was 20 feet tall, was likely more visible than the sign here, than the display here, but was still found by the BSA to be legitimate and legal.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of respondents. Now, I haven't heard petitioner argue either just now or in its briefing that they dispute that even a child, much less a person of ordinary intelligence, would be surprised to discover the application of the phrase located in a window to the display set back only 8 inches from the window here. Instead, their argument seems to be that because there might be some future display in a future case, that might be too far back from a window, that somehow renders ECB's determination arbitrary or that there's some sort of vagueness problem here.
Well,
Not so.
is in the window, is that subjective?
No, it is not. It is a commonly understood, non-technical term with a clear reference point, and that distinguishes this case from all of the cases, including the Cooney
So
case from the Second Circuit.
do we even need to get into measurements?
I don't
8 feet, 8.5? I thought the inspector really wasn't sure, because I thought he said he couldn't really measure it.
He said that he couldn't get inside the space, but he was able to measure it with a tape measure, and it was 8 inches, and the parties don't dispute that. In fact, petitioner has effectively abandoned any
Because
challenge
he
to the
measured
facts.
from the window to the wall that it was hanging on to be 8 inches, so that it had to be within 8 inches at that point.
I believe the 8 inches is from the window pane to the display, not to the substrate wall behind it.
Okay.
That's my understanding of the record, Your Honor.
Oh, I thought it was because it was from the window to the substrate wall, and that he couldn't really get in to measure the distance between the window and the sign. So that's why he says it's 8 inches, so that clearly it's got to be within 8 inches at that point. That's
I believe it's 8 inches. That's what the
So,
parties.
again, we don't need the measurement so long as we see it in the window? It's seen in the window?
That's right, Your Honor. I mean, we use the example of how much is that doggy in the window. I have a friend, he loves plants. He hangs some from the ceiling, displayed in his window. If I'm outside his apartment and I say, look at those plants located in that window, that's my friend's
And if
apartment.
I'm nearsighted, I won't see it, right?
Well, then there might be some additional problems. If a person of ordinary sight who is able to see across the street would be able to say that.
he's arguing that the Microsoft decision where the BSA says, this 8 feet away from the window and you're calling it a sign is really, you shouldn't be doing that. That's arbitrary and capricious.
Sure, a display that by a magnitude of 10 is 8 feet from the window, sure, not located within a window, but that actually underscores that this court doesn't need to be concerned about future examples because there's well-established principles of administrative
So
review.
isn't there an ambiguity in this? I mean, yeah, you can say, well, this one is in the window, it's 8 inches away, it's clear. When you look at it, you certainly think it's in the window, but what if it was 1.5 feet away or 2 feet away?
So we don't dispute that there might be an issue down the road about how far is too far to be located in the window, but just because there might be problems with line drawing doesn't mean that something's vague writ large, much less vague as applied here. These displays are clearly located within a window, and I haven't heard petitioners seriously dispute that.
That's where the administrative agency has to have that latitude, and they have the discretion in terms of how you figure things out. That's where it percolates. If it's down the road, it's down the road.
That's right. I mean, this is New York City. We have thousands, if not millions, of signs.
Counsel, very quickly, on this
Your Honor.
record, they're not seeking to have these signs removed, correct?
I believe we have imposed a $7,500 fine.
That's my point. So as my learned colleague pointed out, it's a question of getting a permit and moving on for this billion-dollar building.
This one can't have a permit because it's too high above the curb level, but to the extent that petitioner is correct that there might be property owners who really don't know if their displays are located in the window, they can apply for a permit, they can seek pre-enforcement review as they did in Microsoft. And the fact that we're really talking about Microsoft in this case, and that's the sum total of cases where anyone has disputed the application of this common sense, non-technical phrase, really belies any sense that property owners are having a problem, some intractable problem with this ordinary phrase.
Thank you.
This court should affirm. Thank you.
The very fact that opposing counsel argues that this quote might be an issue down the road is what makes this rule ambiguous and impossible to administer. They don't want in a window. They want behind a window.
A lot of the zoning resolutions are open-ended. A lot of the, I know because I've dealt with a lot of appeals that had to do with zoning resolutions, and they're all open-ended. And it's subject to whether the DOB and BSA start thinking about a lot, they pull in a lot of factors in to make their determination.
Your Honor,
it's a very fluid process.
That is the case in some definitions. That is not the case here. Payton versus Board of Standards and Appeals, decided by the Court of Appeals within 2020. They looked at the term open space. There were 13.
Yeah, don't remind me about open space. I know a lot about open space.
I know, but there were 13 cross
Many
definitions there.
times.
Your Honor, this is not the type of statement of definition that would require deference to the agency. In a window is an undefined term. It means in a window. The law and the interpretation of that law is on our side. They want this to be interpreted in a way which is merely near a window. They have not been able to answer the question of how far it would have to be back to allow someone to not be run afoul of the law. Alternatively, they've asked for 8.5 feet in Microsoft. They've asked for 8 feet. That's on page 527 of the record.
Isn't there a better way to seek some sort of amendment to this kind of zoning resolution rather than, because you're asking essentially for us to strike it down
I'm
as
asking
being,
you to say
as
that.
void as being ambiguous.
Your Honor, I'm asking you to say here to declare that this sign doesn't fit their definition. I'm not saying that they have to redefine it. I'm saying that they need to if they don't want.
Oh, that's another way of saying striking it down as being vague.
No, I'm saying, Your Honor, we've offered cases such as Highline Development where there was actual decals affixed to a window, and in those cases there was no argument that in a window applied. So I'm saying that here, I'm not making you telling you to make them change the law, but they just can't apply it that way to us.
Thank you.
Thank you, Your Honors.
Kim versus XP Securities.
Your Honors, may it please the court, my name is Alex Sakin. I represent the plaintiff appellant, Mr. Bruce Kim. In dismissing the fraud claim in this case for lack of pleading of justifiable reliance, the court made several mistakes of law. First, it wrongly found as a matter of law that Mr. Kim engaged in no due diligence. Second,
Well, counsel, what diligence did Mr. Kim engage in?
Your Honor, Mr. Kim engaged in several pieces of due diligence. And there really are two questions. First, as you say, what due diligence he engaged in, and secondly, did he reasonably rely on whatever was told to him? In terms of due diligence, he spent 2 months negotiating this employment agreement with Mr. Silvera, in the course of which there were numerous misrepresentations made about the availability of the club and the company's access to
Right, but what did he do once those representations, did he do anything else?
Yes, he was flown to Brazil, where he toured their offices, the headquarters of this company. He saw entire floors full of IT staff, and he specifically asked about the existence of the club, and he was told, sorry, everybody's at this expert convention, which is a huge convention in Brazil.
So why couldn't he have come back the next day to see those experts?
Well, Your Honor, the question is, was he reasonable in relying on that representation? And the answer is yes, and let me explain to you why.
On the representation that they were at the exhibit, or?
First of all, that was, first of all, in this case, as opposed to the other cases cited by the defendants where there was just stonewalling, this was not stonewalling. This was a reasonable explanation given by this high-level executive that everybody's away at this convention, to which he then went, to which Mr. Kim then traveled and saw all these people actually attending. It seemed reasonable at the time. Secondly, you have to understand what the nature of this company is. We're talking about a company with XP, with capitalization of $20 billion, offices all over the world, a household name in Brazil known as the Charles Schwab of Brazil. And we're talking...
But let's look at it a different way. He comes down to Brazil, he flies down there. This club is vital to him because he wants to develop the Hubble. And when he gets down there, he's told that they're at a convention. So you come back the next day to see. This is like the key point in why you're going to take your job with these people. Don't you come back the next day to talk to them?
I understand. I mean, first of all, he was an employee, a future employee negotiating with his future boss. This is not necessarily a situation where it's a buyer or seller of a house. It's not a one-off transaction. So there's...
Yeah, but he said he had better offers. It's not like this was his only offer.
No, that's true, Your Honor. But the point is, Mr. Kim is a sophisticated individual to whom the term club means something. And he reasonably understood that a company of this size, of this magnitude, would have access to the club. It wasn't a question for him. It just seemed obvious that they would have this thing called the club. I realize that the club may not mean very much to people, but discovery will show that in this particular...
Now, really what you're saying, it's not even that they made a representation to him, it's just plaintiff assumed that they're going to have this.
Well, they did make a representation. I mean, there were several misrepresentations made on several occasions that
And
they
he
had the
agreed
club.
that he's not relying on any representations except what's in the contract, and there's nothing in the contract about this.
You're right, there was nothing in the contract. But the point is, discovery will show that it was entirely reasonable in this industry to assume that XP would have the club. It's not unlike assuming that when the CEO of let's say, Boeing Corporation tells you that, Boeing has access to jet engine technology, it's not unlike saying, yes, I believe you, because we know something about Boeing, we know something about jet engine technology, and we would assume that a company of that stature would have that.
But let me ask you this about that analogy. If your analogy is about specific technology at Boeing, about general technology at Boeing, yes, you'd assume that they know how to build a jet engine. But if you're concerned and your interest is a specific piece of advanced technology, and that's the key thing to you, you should be asking about that specific piece of technology.
But Your Honor, he did ask for it, and he was given a reasonable explanation as to why it wasn't available.
Convention.
Sorry?
That they're at a convention.
Yes, that's right. That the people that are available to demonstrate it were not there. So it seemed entirely reasonable.
But he didn't do any follow-up. Like, there was no follow-up, a phone call, video conference, whatever.
Your Honor, he was flown down there by this company. And, to some extent, there was a difference in bargaining power. He's a future employee, and this is his future boss.
Why was he flown down there?
He was flown down there because he wanted to see this convention and he wanted to see their offices, yes.
Exactly. So he was flown down there so that he could actually make some inquiry and figure out whether this was a position for him based upon what he believed they had, right? The club, et cetera.
Right, that's right.
So once he's there, why is he not actually going forth with investigating and asking questions as to the business?
Because the parameters of this trip and of this entire Brazil experience were really set by the company. They told him that it's going to be a one-day affair. We're negotiating this contract. It's going to be a one-day affair. They flew him down there. This is not a situation in which
I'm trying to understand. It's a 3211 motion, right?
That's right.
So can you point anywhere in the affidavit, if there was an affidavit, I don't recall, the affidavit of Mr. Kim or anything in the complaint that says that, he wanted to continue or do some more due diligence, but was thwarted by the defendants?
Your Honor,
Yes or no?
No, there's nothing like that there.
Okay,
He was
got it.
thwarted.
I got my answer.
But the fact is, they set out the parameters of this trip. They paid for it.
I understand that. I'm just saying that, the plaintiff, allegations, if they're missing in the complaint, they can be supplemented by an affidavit, right? I mean, we look at everything, at least that's my understanding on the 3211.
Your Honor, I'm sure
You
I
have
understand,
it?
but the court could have dismissed this without prejudice then, and he could have supplemented this in an amended complaint that would explain that. So the court didn't do that.
The 3211 was as to the fraudulent inducement.
I apologize?
The 3211 was as to the fraudulent inducement. Is that
That's right. That's right. It was only on that issue. Your Honor, I yield the rest of my time.
Good afternoon. Brian Choi on behalf of the respondents. Your Honors, I'll be brief with my remarks. I think on the reliance and the due diligence point, the law is pretty clear that for a sophisticated party like Mr. Kim, he's required to protect himself.
Is he a sophisticated party?
Well, I think Mr. Sagan just admitted that his client was a sophisticated party. I think the pleading in the complaint suggests that he was a sophisticated party. He was experienced with other companies in taking tech platforms and launching them. He was very well versed in what was needed to develop the Hubble, his technology concept that he wanted to work on together with my client.
Could he have justifiably relied upon what the representations that were made by your client? I mean, again, these are sophisticated parties. They're doing certain kinds of business. These representations are made over several months. They fly him down. What's the problem there?
I think the point is that he didn't do any diligence to test the veracity of those representations.
Why would he assume that they're not being truthful or that they don't have the club? Why would he assume that if they're representing that to him?
Well, I don't think the issue that he has an issue with is whether the club existed or not. It's whether the club was in a certain condition or a certain stage of development such that he could use it to then develop his concept.
Right.
And so it was incumbent on him to verify that to some degree as a sophisticated party, and he didn't do anything.
Well, your adversary argues that the setting was, was fixed, that he only had so much time to do questioning, et cetera.
Your Honor, I don't even think he had to fly down to Brazil to do his diligence. I think all it required was a phone call to an IT staff member who had sort of purview over these matters. Like that's what makes his reliance so unreasonable. It's that the lower court recognized that there were so many means available to him to sort of verify the representations behind the club, and he didn't make use of any of those.
Was this information peculiar or within just the sole understanding of your client?
It wasn't, and I understand that he's invoked that exception, but that exception really only applies, well, a few things on that. One, it's applied very sparingly, and it's applied even more sparingly for sophisticated parties who have the resources to be able to conduct due diligence on their own, especially with counsel at their side. Two, you only get to that exception after you've availed yourself of those means to conduct due diligence, and the pleading nowhere suggests that he sort of was able to do that in full satisfaction, such that he could take comfort in those representations.
He was thwarted by the defendants in trying to do that.
He was told that they were unable to, at that moment, show him the club, but they didn't refuse that to him. And I think a really good case on that is the Rodas case, where if someone just tells you that you can't get it, then you at least know that there's a material fact that you have no documentation or verification on, and so you have other means to be able to assure yourself of the truth behind those representations. One is you insist on getting more diligence, and if you're thwarted from doing that, then you insist on a written assurance to do that. There are just so many things that he could have done that he failed to do, and more importantly, the lower court recognized that he failed to plead these things in his complaint, and therefore, as a matter of law, his reliance was unreasonable. In any event, aside from these due diligence issues, the disclaimer clause in the operative contract should control here. The language in that disclaimer clause plus the merger clause in the contract substantially tracks all the language that courts have found would have a preclusive effect on a fraud claim. And I think in the past year, this department has ruled in the D'Artagnan case and the Obnet case, cases that have contracts with similar language that the plaintiff could not reasonably rely on extra contractual representations because he specifically disclaimed reliance on any representations that were not documented in the contract. Unless the court has any other questions, I yield my time and would ask that you affirm the lower court's ruling.
Thank you.
Your Honors, if I may address a point that was raised by my adversary, you hear this constant argument, he could have done more, he could have done more. For one, that is really a finding of fact, he could have done more. And our argument, and as pled in the complaint, he could not have done more, and I'll explain to you why. Because we know, and this is pled in the complaint, in December of 2017, several months after he entered into this employment agreement, things were so dire at XP that XP had to buy an entirely new company that had a version of the club. So it is clear from that alone that had he asked a further question, well, can I please see it? The answer would have been no, because they were lying all along to him that they had the club, and clearly they didn't, as their own actions speak, I think, very eloquently in buying this new company. Secondly, they claim that—
But he didn't ask the question.
I'm sorry?
But he did not ask the question.
He didn't have a need to ask the question. It seemed entirely reasonable that a company with a $20 billion market cap would have this. And again, I think that discovery would show that in this industry, this is entirely reasonable. Secondly, he's a sophisticated party, that's true, but as discovery will show, a sophisticated party with knowledge of what is a club and knowledge of the landscape of this industry would assume that a company like this, just like Boeing, would have access to this technology. And there were no red flags raised either. This is also important to remember. A lot of the case law mandating additional further inquiries relies on situations in which—
Counsel, that's why I don't understand your argument, because on the one hand, you're saying he believed they had the club, they should have had it, and so based upon that, he didn't ask about it. Because he had no reason to ask about it, because given the size of the company, et cetera, he assumed they had it.
Your Honor, he did ask about it. He was told it wasn't available for demonstration. He did ask about it, and he was told repeatedly that they had it. And there were no red flags. I mean, we're talking about a semi-amicable discussion of a future employment. This is not an adversarial situation.
But aren't these questions that we're asking you reasonable questions? Because he, after all, signs an agreement which says it supersedes any prior contracts or representations, and it also says that the plaintiff has not executed it based on any representation not expressly contained in the agreement. And to top it off, he's a sophisticated party.
But, Your Honor, the peculiar knowledge exception does apply here, and I think discovery will demonstrate that this was proprietary technology. We're not talking here about, in the cases where it does not apply, those are cases in which representation is made about a third party, and then the plaintiff fails to follow up with respect to that third party. Or the representation is made with respect to some sort of publicly available information. This is entirely proprietary, as discovery will show. He had no independent means of verifying the truth of this, other than asking again, maybe, and then he would have been told, no, we're not going to do this. Your Honor, thank you very much.
Thank you. Brazil versus O'Neill. You still here?
Yes, I am, Your Honor. Last time, I promise.
Okay.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of appellants. So in granting the petition here, Supreme Court committed two fundamental errors, one legal and one factual. As to the legal issue, petitioner does not dispute that the World Trade Center disability law has one and only one presumption as to causation. Now, the statute is confusing, so Supreme Court's misapprehension of the scope of that presumption is perhaps understandable, because the statutory scheme uses the term qualifying condition twice, because the presumption of causation turns on a showing by petitioner that she has a qualifying World Trade Center condition.
Is your argument, in a nutshell, that you haven't established that the petitioner is disabled?
That's correct, Your
There's
Honor.
no presumption as disability. The
That's
medical
correct.
board has said that she's not disabled.
Yes.
And therefore, all of this consideration about causation really doesn't matter, because yes, if she had these conditions and if they disabled her, this would be a presumption that comes from 9/11. But that's not the issue. It's that you haven't shown disability.
That's exactly right, Your Honor. To be a qualifying World Trade Center condition has to both be a qualifying condition or impairment of health as defined by the Retirement and Social Security law and have resulted in disability. But here, there was some credible evidence to support the medical board's determination that that was not the case for either of the two conditions for which petitioner sought disability. First, as to her asthma, no dispute that she has asthma. That is a qualifying condition or impairment of health under the Retirement and Social Security law. But to be a qualifying World Trade Center condition, it also had to result in disability. But here, petitioner doesn't dispute 11 years of tests revealed normal lung function and that her asthma was well controlled through medication. Instead, her brief focuses on her hip replacement, and I'm going to focus on a right hip replacement first. But there was some credible evidence that it was neither resulted in disability, nor was it a qualifying condition or impairment of health. As to the former, at the first and second evaluation, the medical board noted that she had a full and good range of motion, going as far as to articulate what that range of motion was. At the second evaluation, they noted that she had a normal gait and could stand on each leg individually. Under these circumstances, what the medical board did was it heard from petitioner, it considered her complaints, it evaluated her as it does in these cases all the time, and it gave reasons, applying its medical expertise. And that's owed deference because, and here I can't speak for the panel, but most JDs do not also have MDs. So that's why it's important that that deference exists. But there was also some credible evidence that it was neither a qualifying condition or impairment of health, because according to petitioner, it was caused by her asthma medication. But that depends on a finding that there was osteonecrosis in her right hip. But here, although the 2013 MRI suggested a possibility of osteonecrosis, when the hip was replaced 3 months later in January of 2014, both the pre- and post-operative reports reflected diagnoses of degenerative arthritis.
Is there no correlation between the two?
Not that I'm aware of and not that petitioner has argued, and so
Meaning, was there anything in the record which showed any correlation between the two?
between degenerative arthritis and osteonecrosis?
Yes.
No, there was nothing in the record. So that provided a sufficient factual foundation for the medical board to have determined, as it did, that the right hip condition was neither disabling nor a qualifying condition or impairment of health because no osteonecrosis and not caused by the asthma medication as petitioner contended. So under those circumstances, Supreme Court read a presumption of disability into the law where none exists, and it further substituted its judgment for that of the medical board despite the existence of credible evidence showing that petitioner had not satisfied her burden triggering the presumption of causation under the law. This court should reverse and deny the petition. I'll reserve the remainder of my time.
Thank you.
Thank you.
May it please the court, my name is Tim McEnany for the respondents. Okay, so a couple of points. The first one I'd like to go over, I think that our brief addresses most of the points raised just now. But one of the issues first raised in the appellant's reply papers is their attempt to distinguish Semajopoulos from this case. That takes place on page 7 of their reply, where the appellants say, although the Semajopoulos court rejected respondent's argument that petitioner was not in fact disabled, it did so because he had a previously established disability and was receiving ordinary disability retirement benefits at the same time he applied for ADR benefits under the World Trade Center disability law. This is a really misleading argument. We go over that, and this is actually addressed.
Counsel, I just have one brief question, and maybe you can just direct your answer to that. Who gets to decide the disability? Is it the board or the court?
I'm sorry, could you say that?
Who gets to decide if someone is disabled? Is it the board or the court?
The court is fully authorized to do this if it can determine that there is a disability. This is exactly what this court did in the Semajopoulos
Doesn't that decision rest with the medical board first?
Primarily, but this court has the authority and the power to overrule that medical board determination, just as it did in Semajopoulos.
If there's no evidence to support it.
I'm sorry, Judge.
If there's no evidence to support what the medical board did.
There's no evidence to support.
If there's no evidence to support what the medical board did, yes, then we can.
No credible evidence, Your Honor.
Reach a different.
And we would argue here, and have argued, that there is no credible evidence to support the medical board's determination because the medical board failed to discuss the job responsibilities of Ms. Purcell. In determining that you are not disabled, the medical board is required to articulate the factual basis for their determination that you are not disabled from the performance of duty. That is impossible to do if you don't discuss the actual job duties of a police officer. It's not enough to say, as counsel just did, that she could stand on one foot or she could walk. That's great. Can she pound up 6 stairs in a walk up to an emergency to stop a burglary? Can she drag somebody from a burning vehicle or building? These are all things that they're required to do. Could she perform CPR in that position squatting? Can she pull bags out from underneath benches that way? Is she able to run 6 blocks to an emergency? Obviously not.
But see, counsel, I'm looking at Semajopoulos now, and we know, it's noted in the decision that in that particular case, there was no evidence that there was a disability prior to the World Trade Center. So here, the asthma existed prior to your client's asthma existed prior to her being at the World Trade Center. Is that not correct?
That is not correct.
She didn't have asthma before the World Trade Center?
If she did, it was grossly exacerbated by her exposure at the World Trade Center and attributed to her World Trade Center exposure as a qualifying condition. She was being treated by the World Trade Center program for that asthma.
But when prior to the World Trade Center, she had asthma. It was being treated. It was not disabling. Is that correct?
That's correct. The asthma itself was not disabling, but the sequelae from her treatment for the asthma, which is a World Trade Center qualifying condition, caused the necrosis of her hips, led to the hip replacement.
I'm sorry, that opinion came from her business partner who was the expert witness before the board, correct?
And several other doctors as well.
And the suggestion that her asthma medication contributed to her osteonecrosis. Now that opinion, was that verified by the actual medical records? So when you actually look at the objective medical records, the pre and post-operative report where the surgeons and the people doing what they do there objectively look at the actual bone that they replaced.
Our surgeon,
and just bear with me, and they say degenerative degenerative arthritis, that means you have doctors, treating doctors that looked at it and saw what they saw. So when you weigh that evidence as against the opinion of your client's business partner, that would be a basis for the medical board to arguably reject that opinion and then rely on that and other evidence, including range of motion and lung function, to be able to determine no disabling condition. True?
So we're talking about whether the condition is disabling alone?
Well, no, I said there are two things. One is the asthma.
Okay.
They've determined through the years and through the various objective tests that she had good lung function, although on exaggeration there was some wheezing, but otherwise she had 98% oxygenation and she had good lung function. So putting that aside, and you yourself concede that the asthma was controlled by medication. You just said that.
Yeah, the asthma was controlled.
The issue that you're raising is that her hip replacement was linked to the use of medication that triggered osteonecrosis.
Correct.
That said, when the medical board had that information and then weighed it against the operative reports by the treating doctors that recorded it in the medical record that she suffered from degenerative arthritis, not osteonecrosis.
But the operating surgeon did find necrosis and said that that was the cause of her hip problem. I think that's at record 210. And just another point of finishing up on Samajopoulos, why the argument is so misleading. In that case, there was a prior disability finding, but it was for Samajopoulos' shoulder. My office handled that case. He was out on ordinary disability for his shoulder. The medical board had never given an opinion that he was disabled from his World Trade Center conditions that the court resolved. And if you look at our brief on page 7, the language of the Samajopoulos court is very precise. Petitioner is entitled to have his previously established disability reclassified to include his World Trade Center conditions.
Because of that prior finding of disability.
Not because of, that's not stated here.
Well, I'm looking at the decision, and that's basically what
It says to include his World Trade Center related conditions, meaning those disabling conditions.
Thank you.
Four quick points, Your Honor. Your Honors are correct that Samajopoulos is about the court's ability to overturn a finding of no disability if there's no credible evidence. But here, there is credible evidence. Second, Justice Weber, I believe the record reflects that it's either 1985 or 1986 that Brazil was diagnosed with asthma. It's in a handwritten notation in one of the medical records.
Apparently January 1986.
That's correct, Your Honor. So it did predate the World Trade Center site. Third, the medical board is not required to agree with the conclusory opinions of petitioner's treating physicians. I think that was, Justice Shulman's, your question. And then the last point.
The question was more credibility, where you have a business partner who, I guess, also has an MD, and you have the surgeons, et cetera. You may weigh the opinions on either side.
Exactly. The medical board was permitted to find as it did and was not required to accept those opinions. And the last point I'll make is that the medical board knows what a police officer's job duties are, and here it examined petitioner. I understand that, she doesn't understand how she'll be able to do those functions, so how is she not disabled? But she is not a medical expert. The medical board is, and so deference to the medical board's expertise is owed here. This court should reverse. Thank you.
Thank you. Paul V. Shea. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. Kyle Silverstein for petitioner appellant Dellen Hall. This court should annul the determination as it was not supported with substantial evidence. Regarding the first charge, the trial officer made an unreasonable and speculative leap to reconcile the narratives put in at trial It's unreasonable because there's no testimony from any witness other than Mr. Hall connecting his actions on July 3rd with what was seen 3 days later on July 6th.
I thought there was a conversation with the child.
The conversation with the child occurred on July 6th with the aunt and the grandmother. There was no other evidence. The grandmother, the aunt, neither the actual paternal father were there on July 3rd or had any evidence was presented. There was no evidence presented about what actually occurred on July 3rd.
No medical records? Weren't there medical records as to bruising, redness, which were consistent with the statements by the child?
There was medical photographs and records saying that the child did have a bruise, but there's no evidence linking the two of what happened on July 3rd when there were 3 days in between, and the child only started to complain about it on July 6th to the grandmother.
Didn't he himself
He admitted that he poked the child. Did he not?
Correct, Your Honor. Look, my client admitted that he actually tapped or flicked or plucked the child approximately 7 times. Now, the child says he was hit. The child never actually stated the word punch to any of the witnesses. The witnesses...
Counsel, this difference of whether or not he was flicked, whether or not he was punched, the result of the conduct was this significant bruise on the chest, right? And your client corroborated the touching of this child, regardless of however he termed it, but it resulted in bruising.
Your Honor, my client admitted to tapping the child, yet the bruise that was seen 3 days afterwards was not supported by any evidence at the trial. The trial officer made the speculative leap connecting the two. There was no evidence actually presented.
So it was a coincidence that although your client admitted to flicking or tapping the child with chopsticks, I think he admitted he used chopsticks?
My client said he never used chopsticks.
Okay, so anyhow, so with flicking or tapping the child a few times, that just was a coincidence that the same area where he flicked or tapped the child also had bruising and redness a couple of days later.
Your Honor, the child had bruising, yet the trial officer heard no evidence connecting the two. But furthermore, by reconciling the two narratives, by crediting Mr. Hall saying, I made repeated contact with the child by tapping him, but also crediting the testimony from the grandmother intimated from the child saying he was punched or hit, you have this result that the narrative seems to indicate that Mr. Hall punched the child repeatedly and then poked him repeatedly with chopsticks without causing any commotion when the grandmother and the aunt both testified saying they live right next door. And in fact, the aunt heard the original crying and angst at 8:30 when the mom and when she went first to the door of the child's apartment. Moving on to the charge 4, there's no evidence introduced once again to suggest Mr. Hall made a misleading statement. Mr. Hall was charged with making a misleading statement regarding disciplining a child. Now, the misleading statement definition in the patrol guide is specific. There's no evidence presented that there was an intent to mislead. There was no evidence presented that there was a material fact presented that would have influenced the course of the investigation. Furthermore, there was no evidence presented to show how his statement actually influenced or prejudiced the good order, nature, or efficiency of the department. Lastly, I'd like to just point out that as the investigators on the September 7th interview acknowledged, there's a difference between discipline and an accidental hurting of the child. The investigators said, did you discipline the child? Mr. Hall then stated, I spanked him on the buttocks twice in the last 2 years.
No, he said he was trying to get his attention, and that's why he was poking him. But you can respond to
Sure.
rebuttal.
Good afternoon. Tahira Sadria appearing on behalf of the Police Commissioner. The court should confirm the findings of the Police Commissioner. There was substantial evidence to support the finding that Hall struck the 3-year-old child in the chest, causing pain and bruising. The out-of-court statement of the child was corroborated by substantial medical evidence, which indicated that the bruising that documented the bruising that had occurred and the fact that the nature of the bruising was consistent with the child's report of being poked with the chopsticks. And there was also photographs and video of the
And it was
bruising.
corroborated by,
By Hall's own testimony.
Yeah.
Yes, it was corroborated by Hall's own testimony. And I would point out that Hall's testimony included conceding that after the morning after having poked the child, as he said, or tapped him or whatever, that there was redness, that the aunt had seen bruising and that he himself observed redness. He just did not connect his actions in striking the child's chest or tapping at the child's chest with the redness that resulted. But
And although he stated that he did not do this or engage in this conduct to discipline the child, this was as a result of, was it his mother who called him or someone called him telling him that the child was misbehaving?
that's right. The child's mother had called him and had told him that he was having a tantrum. And with respect to the comments that this was not misleading, I mean, he had the statements that he made in his initial the initial department hearing were not misleading. He knew what was being investigated. He knew that this incident was what was being investigated, and he had made statements to ACS regarding this same incident, and had said that this was in conjunction with the child having a tantrum.
So in the previous case, the argument was made that we should give deference to the medical board as to whether a police officer can or cannot perform their duties with their condition. Should we give the same deference to the commissioner in terms of meting out appropriate punishment for officers of which they supervise or command?
Certainly, as the commissioner is responsible for maintaining the integrity of the department and the public perception of the department. And so maintaining the moral integrity of the department and avoiding officers who are actually endangering the welfare of children rather than protecting them is certainly within the discretion of the police commissioner. If the court has no further questions, I will rest on my brief.
Thank you.
Your Honors, just to go back to the nature of the bruising and the
So
medical...
counsel, I have the same question to you. Why should we not give deference to the commissioner where he or she makes a determination as to the appropriate punishment for those officers under their command?
So the commissioner should be receiving deference. However, they cannot be a rubber stamp on this. The argument is that there's no evidence presented to actually find this to be reasonable, that Mr. Hall did do what the trial officer said he did. The trial officer intimates that he punched the child repeatedly and poked him with chopsticks repeatedly. The medical records say, yeah, it's consistent with chopsticks. Consistent with would be a subjective interpretation. There was no other interpretation given, yet it's still a subjective interpretation.
Is that appropriate? Chopsticks or no chopsticks, poking, flicking to the extent where it causes redness on a child. And this is how old is the child, 3 years old?
At this time, yes, the child was 3 years old. Now, the redness was found, yet it wasn't bruising. Now, consistent with, yes, when you have the story of the narrative saying that that Mr. Hall said, yeah, I tapped him approximately 7 times, and a child says he hit me.
There's a picture in the record of this area of bruising. How would you characterize what that picture shows?
How would I characterize it? I would characterize it as a bruise. Now, that bruise, though, once again, it's not about whether or not the child suffered an injury. It's about what evidence presented at the trial of the officer. And if there's no evidence to connect what Mr. Hall said and what Mr. Hall did to what actually presented at the trial, then there can't be a finding of substantial evidence, let alone any evidence. And to get back to my point about the misleading statements, it's about misleading regarding disciplining the child. If the investigators ask and acknowledge that discipline and says, did you discipline this child? And he said, yeah, I've done it twice. I spanked him on the butt. And then they go on, without asking any further questions regarding discipline, to say, have you ever accidentally hurt the child? And they go in that direction. He can't be found to have intended to mislead them if there was no evidence to prove that he was trying to mislead them. There was no evidence presented regarding any misleading statement or any good order, nature, discipline of the police department. There was no evidence whatsoever. Therefore, this court should annul the determination. Thank you.
Thank you. Flocon versus Andiva.
Good afternoon, Your Honors. Benjamin Ratner on behalf of Flower Construction and John Flower, the appellants in this case. We're here today on the appeal of the lower court's order, which denied the Flower party's motion to compel arbitration pursuant to an extraordinarily broad arbitration clause contained in a construction agreement between the parties. The order should be reversed for three principal reasons. First, it is undisputed that Flower Construction has a claim as defined under the terms of the agreement, and the agreement itself incorporates the construction industry rules, which delegate all issues of arbitrability to the arbitrator. Second, the lower court, in denying the motion to compel arbitration, ignored binding Court of Appeals precedent. In fact, that precedent, the court recognized that it existed, but
Counsel, you filed a mechanics lien against the defendant, right? Because you didn't get paid.
Yes.
You commenced the action because you needed to extend the mechanics lien. The time was running out.
That's not quite accurate. We were served with a lien law section 59 demand, which forces us to either, if we want to keep the lien as of right, we have to
You got to do something. They made you do something. You couldn't just sit on the mechanics lien. They gave you the notice, so now I have to respond to it. And this is this is the way to respond to it, is by commencing an action, right?
That's exactly right.
And then what happens, you commence the action, and lo and behold, you get served with, like, I don't know, 10 counterclaims, not just on the lien, there are two on the lien law. One's on the exaggeration, and the other one was the trust fund. But everything else had nothing to do with the lien law.
That's essentially correct.
Right?
Everything else.
And the third party action, I'm getting good at this. The third party action was against the owner for lien law, trust fund violation, right?
It's alleged, but what it's really about is about the application of the contractual deposit.
Yeah, but that's the only claim that's asserted in the third party action.
That's correct.
Right. So your argument is that everything that's not lien law has to go to arbitration.
That's essentially correct, but even the mechanics lien, the determination of the value of labor and materials provided, that is arbitrable, and there's Court of Appeals precedent on that, and simply beginning.
And whatever gets resolved at arbitration with respect to the value of the mechanics, and then you go on to whether or not their claims to willful exaggeration is valid, but that's going to be at the trial level. That's at the Supreme Court. That gets tried, right?
That's essentially correct, because the willfulness component of this, yes, and any penalties that arise from that, yes, that is for the trial court. But all of the other claims, these are all arbitrable, and they should be arbitrated, including the value of the labor and materials provided. To argue, and as Andiva is doing, that by essentially asserting a willful...
That determination would go to whether there was an exaggeration of the lien. I mean, that would be part of, when you determine what the value of the labor and materials furnished is, you would then be in a position to know whether the lien has been exaggerated.
Correct, but the test for a willful exaggeration of a mechanics lien is not, it's not that the lien is exaggerated. Where parties can disagree about the value of the materials and labor provided.
But it would be helpful to making that determination.
Yes, it would be helpful to make that determination. That's correct. But you cannot assert a willful exaggeration of lien counterclaim and thereby escape an arbitration provision, which is essentially what Indiva's argument is. They're essentially trying to get out of the arbitration provision through assertion of the willful exaggeration counterclaim, and that's just not supported by law, and it basically creates a backdoor way for property owners to escape arbitration agreements in construction contracts. So it's just not the way that the lien law is written. And in fact, if you look at lien law section 35, it expressly delegates or allows a contractor, like our client, to seek a determination on the value of the lien and then have that determination of value be binding. That's what it allows. And that's all we're seeking to do here. And so any arguments about these, about willful exaggeration, it's all meant trying to escape the lien. And with that, I will reserve the balance of my time for reply.
Good afternoon, Your Honors. Robert Angelillo, Arkansas-Bach, and for
Counsel, could you address that argument? I find that to be interesting by asserting the willful exaggeration of the mechanics lien that you would be backing out, effectively circumventing the arbitration clause.
No, I don't think that's correct, and I think that oversimplifies the analysis. Lien Law 39 and Lien Law 39A specify clearly that the determination of willful exaggeration is the province of the court, not an arbitrator. It's not allowed. Now, his reference to Lien Law 35, that's talking about a lien law foreclosure claims, different claim. Lien Law 39 and 39A control the willful exaggeration, and that's the court's province.
So why can't you all go to arbitration and litigate all the claims that you have that are not lien law related? Also resolve the issue of how much the lien should be, how much is owed to the plaintiff, whether it's whatever amount it is. Get a conclusion of that, and then turn to the willful exaggeration, saying, look, you know what? Now you go to court and say, this is the willful exaggeration. The mechanics lien that you said is willfully exaggerated. Why can't you do that?
Well, there's a number of points in there, but the first point is the court has the right to determine in the lien law, in the willful exaggeration claim, the appropriate amount of the lien. How can you determine if it's exaggerated if you haven't determined the proper amount? The arbitrator doesn't have that right on a willful exaggeration claim. I would also point out, if you look at 39A, which is the damage provision is the delta between the exaggerated amount and the actual amount, or the proper amount. The court has the obligation, the exclusive jurisdiction to make that determination. So that claim has to be resolved by the court, including the value of the lien and the value of the exaggeration, if any. But a larger framework here. We don't disagree that any arbitrable claims should be arbitrated. In fact, the court's order, which is, by the way, it's an interlocutory, preliminary, pre-preliminary conference discovery order, and it's without prejudice. It says some claims need to be arbitrated, some need to be litigated. On this preliminary record, it's not entirely clear to me which ones are which, so we'll do some discovery.
You raise a very interesting point. You said that, in terms of the willful exaggeration, let's just focus on that. That's really limited to the court's decision, that you can't have an arbitrator decide that. So then, the way I look at it then, that means then, other than the other claims that are arbitrated, if the arbitrator starts talking about whatever amounts of money owed and whatever comes down to a dollar figure, that's not binding a Supreme Court then. Because the way you phrase it is that under Lien Law 39, only the court has the authority to decide the willful exaggeration claim. Which, okay, I buy that. So that whatever the arbitrator decides to do with respect to the value of the lien and all that stuff, that's not binding a Supreme Court. You can still proceed and go full speed on the willful exaggeration claim in Supreme Court, but everything else that's not related to the lien law goes to arbitration.
Your Honor, the problem with that is some of the issues that are not related to the lien law, in that claim.
Yeah.
For example, the retainage, that's going to determine the value of the lien.
I understand that, but I'm saying that then you would have the argument that whatever happened in the arbitration is not binding on Supreme Court with respect to that narrow issue of the willful exaggeration. Do you follow what I'm trying?
I do, Your Honor, but the issue that I have with that is res judicata. You're going to have an arbitrator's determination on the issue.
You're not following what I'm saying. I'm saying that under the Lien Law 39, it's not binding a Supreme Court.
That's my position in this. The law doesn't talk about non-binding on an arbitrator, it doesn't address that. I would be very concerned with principles of res judicata barring me from making that very argument before Supreme Court. That's why you have Supreme Court make the determination.
Yeah, but you've agreed to this broad arbitration agreement. I mean, that's what Article 9 says. Any claim shall be in accordance with Article 9 and Article 15. And the box that's checked off is that arbitration is the way that disputes are going to be determined. So the determination of how much work has been done and what the value of that work is, in terms of the matter of failure to live up to the contract, it's a matter for arbitration.
If the law precludes arbitration of the issue, it's not up to arbitration. The arbitration clause only goes as far as the law allows. And that's the and the lien law 39.
Why shouldn't the arbitration go forward as to the amount of work done by the plaintiff and how much the plaintiff is entitled to be paid for that work?
Because that'll resolve the a key component of the willful exaggeration claim.
Well, then you get back to the fact, as soon as you put in an exaggeration claim, that ends the contract for arbitration.
Your Honor, what I would also posit here is that this order doesn't even get to the final issue of which claims should be arbitrated and should not. It merely says, let's do the discovery and figure out which ones should be.
Who's to make that determination? Since you've agreed to the American Arbitration Association rules, doesn't that leave it to the arbitrator to decide?
No, Your Honor, under the gatekeeping clause of 7503, that's the judge's determination. The judge appropriately ruled on it here in a very measured manner. He said, without prejudice, to bring this again, if in fact the discovery demonstrates that these claims are arbitrable. I mean, the court fashioned the perfect remedy for this situation. It's not a final decision. It's not impacting construction contract arbitration clauses as a general matter. It's saying, let's do some discovery and get the nature of the claims and see whether they're arbitrable or not arbitrable. Once that discovery is completed, and a motion, they have, without prejudice, to make another motion to compel at that time. There's no reason why that should be overturned.
Just like to address two quick points. First of all, a claim for willful exaggeration of a mechanics lien cannot exist independently of the lien foreclosure claim. So it is entirely reasonable and makes a lot of sense that the value of the materials and labor provided would be determined by the arbitrator as set forth in Section 35 of the lien law, and then separately, any additional findings that may be required, any penalties would be imposed by the Supreme Court for willful exaggeration. So that's point one. The second point is about the scope of the decision or the scope of the order. The court didn't really tailor the order to say what the scope of discovery was. It was an open-ended some discovery. The problem with that is that Andiva's position is that they should get discovery on all of their counterclaims and none of the lien foreclosure claims. But in determining the willful exaggeration counterclaim and getting the discovery on that, they're necessarily going to obtain.
His concern is, and I hear his concern is that lien law 39 reserves the willful exaggeration claims jurisdiction to the court. And to have the arbitrator start deciding issues that have some connection to the willful exaggeration claim is essentially running afoul of lien law 39.
No.
And my way of explaining and my argument to counsel was that, well, maybe then there's no binding effect on Supreme Court because you can't do something that's against the law, right?
Well, the arbitrator cannot act contrary to law. That is correct.
Right.
However, if the text of lien law 39 talks about a finding of willful exaggeration, so the court has to find an element of willfulness.
So there may be some. So what's going to happen is perhaps there's going to be some overlap. There's going to be some. The court can disagree with what the arbitrators decided then, with respect to certain issues that may overlap.
If the arbitrator didn't have a rational basis for doing so, I suspect that may be.
Okay.
Thank you.
Thank you.
Cohen Goldstein versus Chalet.
Good afternoon, Your Honors. I'm Glenn Goldstein. I'm a partner in Cohen Goldstein, LLP, the plaintiff appellant pro se here. I'm going to be very brief. I would refer the court to our briefs. They're comprehensive on all of the issues. The one thing that I do want to address here is the trial court's denial of our motion for partial summary judgment.
Well, the premise of your position seems to be that the IRA's exemption expired upon the judgment debtor's death.
Correct.
The IRA, so to speak, ceased to be qualified upon death.
It ceases to be qualified, correct.
And you cite the Todd case in support for that.
I'm sorry?
Can you identify any statutory support in the CPLR or in the Internal Revenue Code for deeming an inherited IRA to be no longer qualified?
Yes, that's the holding in the case that we cited on that point, as well as the Internal Revenue Code section 408.
But the Todd case is not our case, because in the Todd case, the judgment debtor inherits the IRA. That's not what we have here.
I don't follow, Judge.
You point to the Todd case, supporting the idea that the IRA loses its exemption upon death. But in Todd, it's the judgment debtor who inherited the IRA. Here, it's the judgment debtor who established the IRA who passes on.
Yes.
It's not the same situation.
It doesn't have to be the same situation, Judge. What it turns on is whether Section 408 of the Internal Revenue Code protects inherited IRAs, and it does not. That's what the Todd court holding said. There's a few complementary arguments that go quite along with that. The first argument is that they're relying on CPLR 5205C1 for the exemption of the inherited IRA from the, so that it would lose its protection. But 55...
it's your position that that protection ends upon death.
5205C1 only provides protection while the funds are being held for the judgment debtor.
Respectfully, in my view, it just doesn't say that.
It does. It's
But
exactly what 5205C1
let's look at
says.
subdivision 2.
Counsel, you have to let
I'm sorry.
Let's look at subdivision 2. For purposes of this subdivision, all trusts, custodial accounts, annuities, insurance contracts. What do you think insurance contracts refers to? Wouldn't that refer to a life insurance policy?
It may have referred to a life insurance policy, but that's not relevant.
The protection is not lost upon death if you're dealing with an insurance contract.
Right, but we're not dealing with insurance contract. It specifically includes IRAs as being
Among
being
the rest
protected
of
under
the list,
52.
which includes insurance contracts.
But we're not dealing with an insurance contract, Your Honor. We're dealing with an IRA, and there's specific language that refers to IRAs in 5205C2. And in 5205C2, it travels along the same path as 5205C1, which says that the 5205C1 only applies while being held for judgment debtor. 5205C2 provides protection for these IRAs only if they're qualified under 408 of the tax code. That's it. That's how IRAs are protected, only when they're qualified. If they're not qualified, they're not protected. And even in the Todd court, which held that, the protections are afforded to the individuals who are the depositors of the funds to those accounts. They're not protecting anybody else. I would just briefly refer to the Supreme Court decision, in the United States Supreme Court decision in Clark versus Ramaker. It says funds held in inherited IRAs are not retirement funds. They're not objectively set forth for the purpose of retirement. Then it just continues on, this is the end. Allowing debtors to protect funds in traditional IRAs helps ensure that debtors will be able to meet their basic needs during their retirement. The same cannot be said of inherited IRAs. And that's the United States Supreme Court. There is an enormous difference that is addressed by 5205C2 And the only issue of 55C2 is the inherited IRA issue, not, I'm sorry, the insurance issue. Different types of, there are all kinds of different retirement plans and vehicles. Each one of them has a different response. Thank you.
Thank you.
Your Honors, for the respondent, Joe Andruzzi, I think the focus, and when you have 180-degree positions on this, which we do, is that we're talking about the wrong IRA. The child who inherited this account is not a debtor.
See, that's how I thought that it was referring to, that when you talk about an inherited IRA, you're talking about inherited by the debtor.
Correct.
And not passed on from the debtor to someone else, in this case, the child.
Right. I mean, this is a fraudulent
And the funds are,
conveyance claim.
and correct me if I'm wrong, and the funds from the mother's IRA are transferred into another IRA. They're not just put into some sort of open account, right? There was a rollover.
The funds are rolled over. The analysis under the debtor-creditor law, whether a fraudulent conveyance or transfer with a capital T, right? Not just transfers in a world, a transfer is the nature and character of the asset as it belongs to the decedent. And what 5205C2 and C3 says, it is the policy of the state of New York that an IRA, which was qualified at the time it was made, has this protection. It is deemed to have never belonged to the debtor in the first place. It's deemed to be a spendthrift trust. So the analysis here is not to focus on the receiving account.
And the point made by the appellant was, well, this is there in order to provide for the retirement of the debtor, and therefore it's going to be qualified and protected. But is there any reason to treat it differently when the point of this is that it's left there to provide for the beneficiary who's an infant or otherwise in need of being supported?
So
Why should
I
they
think
be treated differently?
we don't get to that point because there's two actual statutory policies at stake here. The Terms and Conditions of Debtor-Creditor Law, Section 270, 271, 272, 273, and CPLR 5205C1 and C2, that it is the asset itself, not who gets the asset on the day of death, the moment of death, whether or not that is no longer something in a spendthrift trust. And that's not inferable from the statute. And I can understand that people might not like that outcome in an individual case. This was specifically discussed after the In re Gallet decision, which is an identical case in the New York County Surrogates Court in 2003. This was specifically discussed in the Broome County Surrogates Court a little bit later on in the year, that, look, the protection is broad, and the fact that these are declared to be, these are deemed as a matter of state statute, as a matter of state policy, to be spendthrift trusts. If there's an individual outcome that you don't like, it's a statutory control. We've not been sued here for a turnover, which is what's asked for at the end of the reply brief. This is a fraudulent conveyance case under Section 270, 271, 272, 273 of the debtor-creditor law. That Mr. Schlackett has done something, in essence, quasi-criminal, converting this asset.
He did convert it as into an IRA in his name, although still with the son as the beneficiary.
I apologize. It is not in his name at all. It is his name pursuant to decree of the Surrogates Court, New York County. He's only a guardian. It is no individual asset of Mr. Schlackett at all.
How old is the son? Was that in the record?
His son is 15.
So he is a minor.
Yeah.
He's an infant. Okay.
So this discussion of inherited IRA is not relevant to the nature and character of the asset. It's only the receiving account. Finally, I would just say just 2 points if I could, and I apologize. Number one, there is a companion case. So I am asking this court specifically to endorse the rationale of In re Gallet from the Surrogates Court 2003. It doesn't appear to be another case in the First Department, on this, that close, because this is going to bind this case and another case that's companion. And number two, with respect to the necessaries claim, obviously we are asking that the Second Department rule in Jones v. Sitomer be followed. This is a 2016 judgment. You know, unfortunately, the lady died in July 2018. There was no claim at any point when a money judgment was being pursued of a necessaries claim. It's inadequate to simply declare now, you know, by declaration we relied on somebody else's credit. You know, the doctrine of necessaries is for things that are necessary. It's implied in law. It's just not somebody's declaration. Thank you so much for the time.
Thank you.
Your Honors, I ask you to read the specific language of 5205C1 and C2. This is not about, this is only about the protections that are afforded by that statute to IRAs, and it specifically loses protection upon the death of the owner. They're no longer being held for
Counsel, that's really not what those sections say, and it's not what Todd says either. We're talking about inherited by a beneficiary from a deceased judgment. Excuse me, we're not talking about a situation in this case where the IRA is the property of the deceased creditor and then flows to the beneficiary.
That's exactly what happened here. It was the property of the person
And so
until
therefore,
she died.
it's protected. It is
It's
protected.
not protected. It loses its protection under 5205C2. And
What does it say in 5205C2 about death?
I'm sorry?
What does it say in 5205C2 about death?
It doesn't.
Which words are you referring to?
Which what?
Which words are you referring to when you speak about death?
C2 defines the word trust for purposes of 5205C1. And so if it's
And
not
what
a
does it say about
trust, if
death?
it's not a trust under 5205C1, it's not going to be protected at all. So you have to look at the limiting definition of 5205C2. And it defines a trust to include an IRA so long as it is covered by Section 408 or 408A of the Internal Revenue Code. If it's not covered, then it's not a trust for purposes of 5205C1. And because 5205C1 doesn't refer to IRAs, it only refers to quote-unquote trusts. And so you have to know the definition of the word trust under 5205C2. And I would refer the court to the Angeli, Golden and Mandel case versus Angeli, which is directly on point, as well as the Todd case, which is on point. And the purpose of these protections are for people's own retirement. Once you are not using that money for your own retirement, it's no longer protected. That's the entire reason why they made these protections for IRAs. And why inherited
It's protected
IRAs
for the person's own retirement, but it's not protected for that person's minor child.
That's correct. There has to be some protection that's under statute. There is no protection that statutes give to this anymore. And 5205C2 is the only reference point that we have. 5205C1 only protects trusts, and then you need to look at 5205C2 to determine what they mean by the word trust.
And we will certainly do that. Thank you very much.
Thank you, Your Honor.
Jess Karen versus the City of New York.
Good evening, Your Honors. May it please the court, Tim McEnany of Goldberg and McEnany for the appellant. Your Honors, we're asking this court to reverse a lower court holding on a FOIL litigation, Article 78 proceeding, in which the lower court dismissed the proceeding, finding the attorney's fee issue to be moot, as the respondents, the City of New York, the NYPD, had produced substantially all the records that we had requested, but were previously claimed to be exempt.
Right, so under the statute, you would be entitled to attorney's fees if it is shown that you substantially prevailed in the Article 78.
Yes, which the respondents concede that we did substantially prevail.
How did you substantially prevail? The items were ultimately turned over to you. Soon after your filing of the Article 78, you received the
388
annual or
additional
whatever,
pages
yeah.
in addition to the first 3 pages that they initially gave us before we filed the Article 78. Correct, Your Honor.
So how do you substantially prevail given the fact that you really didn't do anything? I mean, that's the Supreme Court said basically it was moot because you received whatever you had been requesting.
Yes, but the attorney's fees issue is not mooted by that, Your Honor. The judge in that decision relied on the Ratley case. In the Ratley case, the reason why the court held that the entire action had been mooted was because in Ratley, the petitioner, fratricide, had represented himself pro se. So there was no attorney fee issue that had to be resolved before the case was dismissed. He was not an attorney. He was entitled to fees. Under the public officers law, we are. We substantially prevailed. That is the condition precedent to us achieving attorney's fees. And the city's only argument remaining is that they had a reasonable basis for initially denying us those records, which clearly isn't true. They abandoned their initial rationale. They abandoned their boilerplate rationales, and they finally settled on the idea that there was some sort of a trade secret.
Right, so they argued that they initially believed that there was a proprietary interest or trade secret in the manual, and that's why they didn't turn it over.
That was not their initial argument, Your Honor. Their initial argument was that there were secret investigative criminal techniques in the MedTox manual, which is a surgeon's screening manual for candidates for the police force, as if these surgeons were out fighting crime. That is not the case.
Well, then they later on said that they needed consent, and then they obtained the consent, right?
Right, so, Your Honor, why didn't they make that phone call during the administrative process instead of waiting for an Article 78 to be filed, which is effectively a fine for my client, which is the very reason the legislature put the attorney's fees provision in the law, because it didn't have enough teeth. And these agencies were creating too much delay and basically disregarding FOIA requests, which the NYPD continues to do. They get some 30,000 FOIA requests a year. There are 13 or 14 FOIL officers. That's it. That's why they automatically deny all FOIL requests. I make a lot of them. They all get denied initially. And here they abandon all their other exemption arguments. They're all gone. So if they were going to do this, they should do this in the administrative phase. They made no attempt to do it. They made no attempt to comply or produce until we filed an Article 78 proceeding at expense to my client, who should not have to shoulder that.
Thank you.
Good afternoon, Your Honors. May it please the Court, Diana Lawless for the respondents, the City and the Police Commissioner. I'm going to start with a procedural issue. I think it's an important one here. This appeal should be dismissed. The order here, the error claimed is that the Supreme Court dismissed the proceeding without rendering a termination on the application for attorney's fees. That's true. But the petitioner fails to mention that Supreme Court later addressed and denied the application upon motion for re-argument in an order he hasn't appealed from that was entered 4 months before he perfected his appeal. So the order he's seeking relief from is not, the analysis about attorney's fees is not in that order. And he knew that when he filed this brief. That order would have been appealable because it addressed the merits of the motion, and it effectively granted re-argument. It granted actually what he seeks in point 1 of his brief, which is a consideration of the issue. But even if this court could consider the order on the merits, if this court can consider the issue on the merits. We concede that the petitioner substantially prevailed, but he's not entitled to attorney's fees because the NYPD had a rational basis for declining to provide the manual under Public Officers Law 89-4C2.
So what was the rational basis?
The rational basis was the exemption for trade secrets.
But you know, the thing is that you knew about the trade, what changed between the time of that denial by the appeals officer saying trade secret and the filing of the Article 78 when they said, oh, you know what? Here's our answers, here's everything, we got the consent. So what happened between the denial from the appeals officer to the commencement of the Article 78?
I can't speak to that, Your Honor.
Yeah, it's a simple phone call.
Well, I don't know if it's a simple phone call.
I don't know.
But all that matters is for the state.
All we know as a matter of record here is that once the Article 78 petition got commenced, lo and behold, they got the documents.
Right, but all that matters, Your Honor, for the purpose of this analysis, it's not the timing, it's whether or not the initial decision's reasonable, even if it's wrong, and the cases are clear on
Well,
that.
see, that is a question, because it seems interesting that you initially deny saying, oh, trade secrets. Once, again, the Article 78 is filed, and you actually do some investigation, you find that it's not a trade secret, and that you can, in fact, turn it over. So then now one has to wonder and question the initial denial citing trade secrets as to whether that was rational or even truthful.
Well, Your Honor, I think that all that this record shows is that I don't think that we took a position as to whether or not it was correct that we believed it was a trade secret or not. I can list the reasons why we thought it was. But I just want to make clear, because my time is short, that it's not that we said that we found out it wasn't a trade secret. We said that the company was okay with us disclosing it.
Right.
I think that's two different things. But we believed it was a trade secret for several reasons. We have to show that it was from a commercial enterprise. It was a commercial enterprise who provided a document to us that we paid them money for.
Yeah, but you got the consent from the company so quickly. It's like, I mean, it just kind of like, you kind of just got to scratch your head on that one, right? You get the Article 78 petition, and then you call the company and you got the consent.
Well, Your Honor, I don't think it was that quick. It was 2 months after the filing of the Article 78.
It's still pretty quick.
Your Honor, I mean, this is not like there's only
In litigation sense, that's pretty quick. 2 months.
I don't know. We have a very, as you know, everybody's a very heavy caseload, so I don't know.
I'm not, you know what,
that
you yeoman's work there. I'm not yet.
But, it also does contain a disclaimer. It couldn't be sold, rented, leased, loaned, given, shared, provided without written consent. It's a 400-page document they provided with their analysis of medical things that they provided to us. We had to just have a reasonable belief that they would have a substantial injury. And we did, and we also turned over the portions we didn't believe were exempt, which happened to be the non-substantive portions, I would say. And we didn't, I think it actually helps us that we didn't make the disclosure until we consulted, because it showed that we reasonably believed we could not disclose it. Your Honors, I ask that you either dismiss the appeal or affirm.
Thank you.
The statute does not say that you have to have a reasonable belief. It says that there has to be a reasonable basis. Here, there was no reasonable basis for the denial. This company had no problem with this being disclosed. There was some kind of a form note that was in the book.
Well, they said they had a contract with the company. Based upon the contract, it appeared to be trade secrets. So, I mean, they are claiming or arguing that there was a rational basis.
Yeah, they're arguing that they had a rational, a reasonable basis for not disclosing this information. But let's remember the path that was taken to get to this point. They tried 8 different arguments, abandoned all the prior arguments, and only settled on this argument on the eve of the Article 78 petition. Once they did that, there's no reason that they couldn't have made this phone call earlier or checked this out earlier. To have a reasonable basis, you may have to do a little research and not just...
Whose burden is it to deny the request based upon trade secrets? Is it you who has to overcome that it's a trade secret? Or is it the city that has to establish that it is a trade secret?
I would say the city would have to establish that it's a trade secret, or that there's...
If they're going to deny the request based on trade secret.
They would have to actually show what they researched to come up with that conclusion, not just a note in a book from the manufacturer that could be any kind of a form note.
Well, I think the simple factor is if they got from the vendor saying, no, you cannot, I'm not giving you consent, and that's the end of it. Your case would have been over.
Right, as if that was the authority, Your Honor, and clearly not.
A simple phone call.
A simple phone call, all it took. So we did all that work, Your Honor. We're just asking that we be granted an award of attorney's fees, reasonable attorney's fees for the work that we had to do to get a hold of this information. Ask that you reverse the lower court and award accordingly.
Thank you. Greco v. Choice Associates. Someplace to go.
No, we still have it.
Keep it on.
Good afternoon, Your Honors. My name is Albert Dowdy, the attorney for plaintiff appellant Greca. We respectfully request that the lower court's decision be reversed and plaintiff's summary judgment motion granted.
I got a question to ask. That I'm reading this record, and it's just kind of something I want to. The accident happened on the Lower East Side.
Correct.
Any idea why they went to Jacoby Hospital in the Bronx?
That's what I've been wondering for 4 years, or almost 5 now, Your Honor.
Because the way I understand it is that the plaintiff was put in the back seat of the car. He's bleeding profusely, according to him, and the driver is taking him to the Bronx. And
Absolutely.
I think between the Lower East Side and the Bronx, there are at least 10 hospitals along the way.
I respectfully submit to this court that the clear truth that is not reflected by the record is the fact that the person who drove him is the defaulting GC principal, a Mickey Mouse contractor, who was at the same time working.
I wouldn't use that term, Mickey Mouse. You might get in trouble for that.
I'm sorry, my apologies, because Mickey Mouse is a very favorable character for a lot of people. But what I try to mean is I'm not trying to deliver. I'm saying that this is.
Do we know why he defaulted? Lack of insurance?
Correct. He was a super in one of the buildings that is owned by the defendant. And at the same time, they give him the contract to do a job, which means that he's basically trying to chew much more than he can swallow, basically.
Okay, so back to the record and to the case. So what the Supreme Court found that there are issues of fact. So why are there no issues of fact from your point of view?
Plaintiff met his burden with his own deposition testimony, Your Honor. It's clear the record, he testified how the accident happened. It was upon defendant then to produce admissible evidence to raise an issue of fact. The only items of evidence that they submitted were 3. One is an unsworn statement from the driver that drove plaintiffs, the GC, the defaulting GC that drove plaintiff all the way from downtown Manhattan to the northern Bronx while plaintiff was bleeding. That was an unsworn statement. The other piece of evidence that they submitted was an affidavit prepared by plaintiff's supervisor, who was not even at the job site at the time of the incident, and he admits in his own affidavit that all he learned about this accident was from this GC driver that drove plaintiff all the way from downtown to northern Bronx while plaintiff was bleeding. The other third piece of evidence that they submitted were certified medical records from Jacoby Hospital, which as certified records, they are definitely admissible into evidence. However, the entries upon which defendant relied to raise an issue of fact in this case are inadmissible entries.
Why isn't, counsel, why isn't the statements therein that his hand was cut by glass, why isn't that germane to diagnosis and therefore admissible?
I first respectfully submit that that statement cannot be attributed to plaintiff. It's clear the case law of this court that we know that plaintiff could not speak English. We know that the first statement that was written in that record came from this GC driver. That's what plaintiff testified to, that he did not speak. All the time that he was in the hospital, he used translators that were providing by the hospital.
But wouldn't those arguments be best reserved to be argued at trial for a jury as to what weight this record should be given?
But it's, Your Honor, I respectfully submit that even if this case were at the trial stage, these statements should be redacted from the record because they may not be attributed to plaintiff.
Well, what if the plaintiff told Sakaj that he was cut by glass?
I'm sorry, Your Honor?
What if the plaintiff told Sakaj, if the plaintiff told Sakaj that he was cut by glass?
That is absolutely not true. He never told. That's a story that Sikaj is the driver of the car, the GC. He's the one that drove him there, and he made up this story, clearly. Then, you know, his unsworn statement, we already established that by itself is not admissible evidence. However, this is how he got into the record. Clearly, the medical record, if you look in totality, Your Honor, an hour later, after they do that glass inspection through the x-ray, they question plaintiff. They say, what is the story with this glass? Because there is no glass in your hand. And then there is a medical, I believe it's page 744 of the record, that the whole story is changed an hour later. The record reflects that plaintiff fell on a sharp metal stud while he was at work. So this is clearly the record itself is such that if you look through it, you see the lies of the glass theory that came from an interested party, the defaulting GC. But let's leave that aside for the moment.
And we'll leave it until your rebuttal. Thank you.
Okay, thank you.
Good afternoon. May it please the court, Lisa DeLindsey for respondents. And I would like to point out I am wearing a Mickey Mouse face mask. Anyway, I've been listening to a lot of cases today, and we've been discussing the statutory dictates that the law is driven by. And so that is why a lot of my brief is focused on the plaintiff's burden. And he says that this argument was not raised below, but it's axiomatic that the court can review legal issues that were not necessarily presented below. So the statutory burden of a movement on summary judgment is admissible evidence and sufficient evidence to eliminate all issues of fact. So that's why I spent a lot of time in my brief pointing out the lack of facts that were presented in the moving papers. So it's my position that he did not meet his burden in the first instance.
The plaintiff submitted his deposition testimony where he detailed how the accident happened?
He did say, yes, an accident happened. But where was he working? What was he doing? What was his job? I've handled a ton of labor law cases. I always get there's always the whole transcript in there. There's always affidavits confirming what was done. This is the first time I've only seen like a few pages of testimony about what the job site was, where it was, what was going on, where's the contract, who are the players in this whole scenario of this renovation project or whatever else was going on. Again, it's not my burden to show that. It's plaintiff's burden to show the role of everybody.
Well, doesn't he testify that he fell from the 5th to the 4th floor through the floor to the inadequate floor protection?
He did say he fell through. I don't think he actually went to the ground.
Right.
Well, while working on the 5th floor,
yeah,
a piece of wood that had been placed as a temporary path shifted, causing him to fall through an open area between beams. Testified he prevented himself from falling by grabbing a metal stud attached underneath a beam.
Exactly, which brings up an interesting point that he also later testified that this flooring could not be attached because they had to lift it up to do their plumbing work. So that leaves the quandary of how can you have a safety device?
But why doesn't what Judge Reber said to you from his deposition, why doesn't that establish his prima facie case?
Because you can't have a safety device that needs to be moved because we have to put plumbing underneath. You can't attach the safety device, the flooring, because he directly testified, we have to lift this up to put the plumbing underneath. It's movable. That's also his testimony.
Well, the only safety device is not necessarily these pieces of wood which moved. I mean, there could be other safety devices. Obviously, you don't send someone up on the 5th floor to fall through to the 4th floor without protection.
Right, but yeah, just right now the focus is on the floor.
Why doesn't that make out a prima facie case?
Again, if that does make out a prima facie case, I think the lower court was correct in finding issues of fact onto where the accident happened, how it happened, how he was injured, who said what, who said when.
Well, going to raising, assuming that the prima facie is met, you're saying that there is issues of fact. You put in sufficient evidence in the record to raise issues of fact, right?
Yes.
Warranting denial of the motion. So one of the arguments that I remember reading is that there's an argument, or at least an assertion, that the plaintiff fell on the street outside, and that's how he cut his hand on glass.
Yes.
I went to the medical record. Nowhere in any of the medical records that they have any indication that he fell on the street, unless I'm reading it. And the medical records themselves were all over the place in terms of what the injury was here. I mean, it was like one said one thing, another said another thing, and then the third one said something else. It's like, what is? I mean, we use medical records for the purpose of diagnosis, but these medical records were all over the place. So
I did, yeah, there is one citation, and it says, source of history, patient, fell with outstretched hand onto a piece of metal. He notes that he was walking from work when he slipped and fell sideways. That's in the record. And,
yeah, I know, I saw that. And then the next record, the next medical record, you know, it's all right.
Okay. If there are no further questions, I ask that this court please affirm the lower court's decision.
Your Honors, if I may address that where Judge Owing left with the issue of that note and the fact that the medical records are all over the place, it's very clear, because even that note, the Judge Owing's question was, where does it say that he fell on the sidewalk? Clearly the note that the counsel read does not mention the word sidewalk anywhere. But be that as it may, it is very clear that based on the case law here, Juarez is the case from this court, 2018, and Judge Weber was part of that panel. This court reversed the same trial court and granted plaintiff's motion for summary judgment when the evidence the defendant submitted in opposition to plaintiff's motion was a workers' comp filing signed by plaintiff himself. And the argument was that because the defendant did not meet the burden of producing a translator who would be competent, duly qualified to make the translation between plaintiff and his own attorney, then that record was deemed inadmissible and plaintiff's motion was granted. And as recently as a few months ago, in the case of Sanchez versus Juan Burgos, this court basically, and I believe Judge Schulman was part of that panel, this court decided clearly that the fact that the pre-admission hospital report was inadmissible because plaintiff was not English speaking, just like plaintiff here, and the defendant failed to meet the burden of bringing a translator who would be objective and duly qualified to make the translation of the entries that were reflected in the pre-hospital admission report. The only case that the defendants cite in support of their argument is the Pina case, and that's where Judge Friedman and Judge Owing were part of the panel in 2018. And that case is totally different from this because plaintiff was an English-speaking plaintiff in that case, and there were no issues here. Here we have double problems. Not only the plaintiff doesn't speak English, but they failed to bring the doctors and the nurses who allegedly wrote those records to make them testify under oath to relate these entries and attribute them to plaintiff. And all I want to finish with this one word, if you allow me. If the court were to allow these scenarios like this to defeat summary judgment motions, I can almost guarantee you that all these, I hate to call them unscrupulous contractors, will make sure to drive plaintiffs that are bleeding and probably with broken bones to the corners of the hospitals, give different stories there, say whatever they want. That is enough to defeat a summary judgment motion.
Thank you so much, counsel. Have a great day.
Thank you.
And Casanas versus Carly Group. Group. Whatever. Casanas, I don't care. Go right past the Bronx. Yes, counsel.
Yes. Good afternoon, Your Honors. Dawn Wilson on behalf of the appellants, the Carlyle Group and Richard Casanas. This is an appeal of a non-jury trial in which the trial court found for the plaintiffs that they had a 100-year lease for $100 a year in an apartment consisting of 2 units in a building that was owned by a company, in turn owned by the parties' parents. In reaching that decision, the trial court erroneously admitted the alleged lease into evidence in contravention of the best evidence rule. In addition, the trial court...
Under the circumstances, why was that not the best evidence?
I'm sorry, Your Honor?
Under the circumstances, why was that not the best evidence? Wasn't there some type of fire or something wherein
Yes.
the original lease was?
Yes, there was a fire, Your Honor, that the plaintiffs claim destroyed an original lease, but there was significant other evidence that was adduced at trial that show that lease, this copy of this alleged original lease, was manufactured by the plaintiffs. There's multiple copies of the alleged lease that ultimately were produced by plaintiffs when they originally claimed there was only 1 copy. Those copies contain significant differences from the alleged lease. that are
I'm sorry,
important.
counsel, you had a handwriting expert at trial?
Yes, Your Honor. We had Peter Titel, who is a world-renowned forensic document examiner, and his testimony was unrebutted.
And his testimony was?
Unrebutted, Your Honor.
I know what unrebutted is. What was his testimony in terms of the fabrication?
I'm so sorry, I thought you didn't hear me. His testimony, he went through all of the differences in these copies of the documents and what that could mean. He also testified, and this is significant, that Elizabeth Casanas' signature on the document was not consistent with her signature at the time the lease was supposedly signed in 1990, but rather with her signature in and after 1996. Mr. Titel also testified that the purported initials of Carlos and Alida Casanas, those would be the representatives of the landlord, were not consistent with their known writing samples. In addition, the defendants presented the testimony of Alida Casanas, again, one of the members of the landlord, who was still living at the time of this action, and she testified that she did not sign the alleged lease or the memorandum of lease, which was later, supposedly later prepared, or initial the writer. She also testified that she would not have given this apartment to her son and daughter-in-law. Instead, she said that the plaintiffs just took the apartment without permission.
So, counsel, this was a non-jury trial, is that
Yes.
correct? How long did it take?
The trial was 20 days.
20 days. How many witnesses?
There were...
My point was that this Judge Ingoran went through a Herculean task with this case in terms of the trial days, trial hours, and the witnesses, as well as the documents that were presented at trial. Why should, and he also obviously evaluated the credibility of the witnesses. I've sat on one of the prior cases involving these individuals. He observed the credibility of Alida, the mother, of the 2 sons, everyone else who testified. Why should we disturb his credibility findings? Because you mentioned the lease, you mentioned the fact that, maybe a sham lease, etc. He saw the lease, he listened to the testimony, he made a determination. Why should we not credit his determination? And why should we in any way tinker with his determination?
Because, Your Honor, while credibility determinations are generally given a great deal of deference by the appellate court, they can be set aside when the decision reached could not have been reached under any fair interpretation of the evidence. And we posit that this is a case that fits that bill, given all of the other evidence. And in reading the trial court's decision, the bias that the court showed in trying to ignore or fit the other evidence into a sort of preconceived notion of what would be fair here. I.e., if the parents gave one son something, then it's only right, it only makes sense that they would have given the other son something. That's fine, except that he distorts the evidence to fit that notion, and that's not what happened here, in fact.
Thank you. You have time on rebuttal.
May it please the court, my name is Jethro Eisenstein, and I represent Peter and Elizabeth Casanis, who are the respondents in this case. The decision of the trial court, as Justice Weber has pointed out, rested on the determination of the credibility of witnesses made after a 3-week trial. As the appellants have acknowledged to this court, the standard of review applicable here is highly deferential. What the appellants have done is basically tried to re-argue the factual issues that were all presented ad nauseum over 21 days. Every single point that they have made here was made to Justice Engoron at trial. Justice Engoron viewed the totality of the evidence and determined that the plaintiffs had sustained their burden by a preponderance of the evidence. What the appellants are doing again is cherry picking. Now, that's what advocates do, is they cherry pick. But with respect to, for example, the handwriting examiner, Mr. Titel, he testified that the signatures of the parents on the lease were not only consistent with their signatures, but consistent with their signatures as of 1990, which is when the lease was signed. So there's an enormous amount of evidence from Mr. Titel, they're unrebutted.
Well, Carlos died in 2008, didn't he, the father?
Correct.
And the mother was still alive.
The mother was still alive, but if you read her testimony at trial, she didn't know,
Right.
to be blunt about it.
She only thought she had one son.
Yeah, but that could have been because she was mad at him. But she said she only had one son. She only recognized one son.
Right. So, I mean, there's, and also, the trial court permitted her, the appellant's lawyers, to read her deposition,
Right.
at which she said she didn't remember whether she had signed the lease. It's too long ago.
Right.
So there's
Did the notary who used to work at Saks Fifth Avenue and who is now a nun, did she come in to testify, or did she just submit a affidavit?
She appeared by, she came in and let me start again. I found her, part of the record, in 2018, and I offered her for deposition by the defendant's lawyer, by the appellant's lawyers. She testified that she had had no contact with Peter Casanis in 18 years, that she recognized the document, the document she had signed. All poor people were there, and Mr. Titel.
But she said she didn't take, she said she did not ask for identification, right?
That's correct.
So she didn't know who was who, but she knew that there were 4 people there.
There were
and they
4
signed
people there, and the 4 signatures were identified as those by Titel, by the handwriting expert, as those of the parents. So there, you know, I mean, I don't know how the appellants believe that this notary somehow, after 18 years, came out of a convent and said that that this was somehow contrived. In any event, what Justice Engoron did was he reviewed all of the evidence. He listened carefully to all of the points that the appellants had to make, and they're really just reiterating those points again in this court, where, unlike in front of Justice Engoron, the scope of review is, as the Court of Appeals has said, extremely deferential. And if the court has no other questions of me, I simply ask that Justice Engoron's trial decision, based on all of the evidence, be affirmed.
Thank you.
Just a few points. This court has previously held in a case called Glatter v. Borton that the authenticity of a signature on a document does not, in and of itself, establish the authenticity of the document. And expert, Mr. Titel, testified about all of the ways, especially in these modern times, which a document can be manipulated or altered or made to see something it's not.
But the expert did not, I'm sorry, did the expert expressly testify that the secondary evidence was manipulated?
No, but he did point...
He anticipated that because of how people know how to do photoshopping and various, manipulations, that potentially could happen, but it wasn't in this case that he actually said it was manipulated, correct?
No, he didn't reach that conclusion, but he did testify that the wife's signature was inconsistent with her signature in 1990 and was consistent with her signature in 1996. Now, Judge Ergeron, he said, oh, well, landlords, tenants, they always sign leases at different times in different places. And that's certainly been my experience in my lifetime. But to wait 6 years for a document of this magnitude with the thing of the financial impact on your family, I say that makes no sense. And that right there is evidence that this was a sham document.
Thank you.
Thank you.
Thank you.
What? I said we were dead last. I do enjoy listening to the other arguments, though, so I don't mind it.
Yeah, I enjoy it.